for meditation. Please be seated.
Recording in progress.
Honourable members, please take your seats. Honourable members will recall that on Wednesday, 22 October, during questions to ministers in the Social Services Cluster, questions directed to the Minister of Basic Education stood over in terms of Rule 1441A. Likewise, on Wednesday, 29 October 2025, during questions to the ministers in the Governance Cluster, questions directed to the Minister in the Presidency stood over in terms of Rule 1441A to 26 November 2025. However, due to ill health of Deputy Minister Morolong, questions 1055, 1056 and 1047 again stood over in terms of Rule 1443B. In terms of Rule 1442B, the questions have been published in the order in which they previously appeared. Consequently, in addition to 30 minutes, will be added to today's question time for this purpose as provided for in terms of Rule 1375B. Replies to questions which remain unanswered at the conclusion of 3 hours and the additional 30 minutes will be provided in writing and published in Hansard in terms of Rule 1431. The first item on today's order paper is questions addressed to ministers in Cluster 1, Peace and Security. There are 4 supplementary questions on each question. Parties have given an indication on which questions their members wish to pose a supplementary question. Adequate notice was given to parties for this purpose. Members who will pose supplementary questions will be recognized by the presiding officer. In allocating opportunities for supplementary questions, the principle of fairness, amongst others, has been applied. And at this point, before we proceed, honourable members on the virtual platform, please ensure that your microphones are muted. Honourable members. Honourable members, please make sure that your microphones are muted. A member who is supposed to ask a supplementary question through the virtual platform is unable to do so due to technological difficulties. The party whip on duty. Deputy Minister, I don't know which one, please mute your microphone. Could the table also please assist me because I don't see the full name so that I know who I have to caution. I will start again. If a member who is supposed to ask a supplementary question through the virtual platform is unable to do so due to technological difficulties, the party whip on duty will be allowed to ask the question on behalf of their member. When all the supplementary questions have been answered by the executive, we will proceed to the next question on the question paper. Now, the first question has been asked by the Honourable Moshlala to the Minister of Justice and Constitutional Development. The question is, given that Advocate S. Batoy and Advocate A. Johnson testified that an oversight judge had been appointed on 11 October 2025 to support the investigating directorate against corruption, whether she has found that the specified appointment is lawful and legitimate, since there was no public appointment announcement, ministerial statement, presidential communication, departmental notice and/or government gazette publication confirming the appointment. If not, what legal basis exists for remunerating a judge whose appointment has not been formally gazetted and/or publicly disclosed? If so, whether the appointment complied with the principle of transparency and administrative justice in the establishment of anti-corruption oversight structures? If not, what is the position in this regard? If so, what are the relevant details? The Honourable Minister.
Thank you very much, Deputy Speaker. The new Section 228 of the National Prosecuting Authority Act, which is yet to commence, provides for the complaints and accountability mechanisms to be headed by a retired judge who is required to investigate any alleged improper conduct or misconduct or any conduct which has resulted in an improper or prejudice on the part of any staff member of the ID and Investigating Directorate Against Corruption. For this reason, to commence, it requires the making of regulation submission of the regulations to Parliament prior to publication in the Gazette, the appointment of a judge and proclamation for the commencement. The process to appoint the retired judge started in 2024, which then identified Judge Takalani Joseph Raulinga and consultation with the Chief Justice as required by the laws, enjoins the minister to do so before making that appointment. On the 10th of October 2024, the Chief Justice addressed a letter to my predecessor supporting the appointment of Judge Raulinga. In this regard, I approved the regulations on the 10th of October 2025. The outstanding steps are the submission of the regulations to Parliament, finalization of the appointment process, and proclamation to bring this section into operation. These processes are underway. The process of appointment is being conducted in full compliance with the relevant legislation and prescript. The judge has not yet commenced with his duties and will be remunerated based on submission of invoices for work that has been done. So to date, the judge has not submitted any invoice as the work has not started. And this will happen only when this is brought to operation. And the public pronouncement will be done once Parliament has been consulted and publication of the regulations have been done. Thank you.
The first supplementary question will be asked by the Honourable Mushlala.
No, thanks so much, Deputy Speaker. Minister, beyond the legality and transparency issues around this so-called oversight judge, can you explain how an oversight structure that operates in secrecy without a public mandate, without a traceable appointment process, and without any measurable performance indicators can ever guarantee independence from political interference, especially when the Investigating Directorate Against Corruption is currently handling matters that implicate the senior officials, ruling party employees, an individual with access to state security structure? What safeguard, if any, exist to ensure that this undisclosed oversight judge is not being used to influence decisions on who gets prosecuted, which cases are prioritized, or which politically sensitive investigations are quietly suppressed under the guise of oversight? Thank you.
The Honourable Minister.
Maybe Sonzo ke tlhalose ka Sepedi, Honourable Mushlala. A gona judge e thomileng go bereka. A gona sephiri se se dirwago. Because molao o re ga re appointa judge swanetse gore re sepele ka open and transparency, because re ya go Chief Justice re gopele concurrence re wa dumelana le rena na go appointa judge eo. A re fetša go e hwetša re boye re publish gore judge eo ya bereka, especially ha ile gore ba ile gore ba tšere modula fase ba feditše mošomo setse ba le modula faseng ba golela go dula fase. Yaanong ka re ka se mmolediše gore o a bereka ka gore di-regulation tše di mo fang tokelo ya go bereka ha di sotle into force. Once the regulations are into force, then the judge will be working and they go together. Di sepela ka moka for publication. There is no secrecy. And that is done with Parliament. So the regulations di tla Parlamente di bolele gore ke tše di-regulations tsa IDEC and together with the judge. So there's no secrecy. Thank you.
The second supplementary question will be asked by the Honourable Motaung. The Honorable Motaung.
Deputy Speaker, was Batoyi lying when he testified about
Honorable
the judge?
Mkalipi. Honorable
The minister
Mkalipi.
must confirm here.
Honorable Mkalipi, that is not allowed and it is not a point of order and I have not recognized you. Is there anyone from the ANC who will take this questions of the Honorable Motaung? Please proceed, Honorable Member.
Thank you, Deputy Speaker. Minister, can you please answer this question? Whether has consulted the Chief Justice in the appointed or retired judge to oversee the work of the IDEC?
The Honorable Minister.
Thank you very much. Yes, the Chief Justice have been consulted by my predecessor on the 10th of October, 2024. Thank you very much.
The third supplementary question will be asked by the Honorable Breitenbach.
Thank you, Honorable Deputy Speaker. Honorable Minister, can you detail the exact process that was followed in the appointment of this oversight judge and provide the empowering provisions for this appointment? Thank you.
The Honorable Minister.
Thank you very much. The process of appointment is that with any other judge that we do, so would identify based on the availability of the judge, especially those that are retired, because some of them might be retired, but because of health, they will not be able to do the work. And then you'll consult them and ask if they're available to do public service work. If they agree, then you approach the Chief Justice. Sometimes you go to the Chief Justice because she would have a pool of judges that have made themselves available after retirement for the work that needs to be done. And then, but by law as well, we have to write formally to the Chief Justice to say, this is the identified judge. This is what the judge will be doing. You described all the details. You also describe if there's going to be additional remuneration that the judge is going to receive over and above the money that they receive in terms of their pension. And then the Chief Justice will look into terms of the records and then write formally to say they confirm. And again, the Chief Justice checks with the judge. If the judge agrees, because some would say in this area of work, I don't want to do it. And then the Chief Justice then will agree and then will send it that it's within Section 222A of the NPA Act that gives this provision of work. And out of that, for the judge to start working, it prescribes that we must be able to bring the regulations to Parliament. So once the regulations are into effect and Parliament has considered the regulations, then we are able to get the judge to work. Thank you.
The last supplementary question will be asked by the Honorable Litchfield Shabalala.
Thank you, Chair. Minister, can you clarify for us? Two advocates, Batoyi and Johnson, said a judge is appointed. They didn't say judge is being appointed, that's present continuous. So the process is on. They gave us a past perfect, a judge is appointed. So did they lie as two advocates? Gape, Minister Ori, the judge has not invoiced. But how are we sure as a house, gore mmereko o ntse o tswela pele? And the invoice, even if it's after, it's a big data. We don't have an assurance of that. So can you assure us that when the invoices come, they will clearly reflect a present and not, not backdated, because they can be backdated without disclosing, but the amount will tell us that this is a backdated amount. Thank you, Chair.
The Honorable Minister.
Thank you, Honorable Litchfield Shabalala. The judge has not commenced work, so the judge can invoice. Previously, there were discussions whether he must be paid fully or per invoice. So the agreement is that the judge will pay per invoice of work that has been done. The judge has not started work because what will give effect to the judge doing the work will be the regulations, which I'm currently finalizing. Actually, I've finalized, as I said, they are in Parliament, they are to be submitted in Parliament. They're just going through legal assessment for submission in Parliament. So the expectation from where I'm sitting is that the judge will start early next year in terms of the process once Parliament has given me a go-ahead to be able to start implementing the invoice. So there can be even an invoice that is backdated in terms of that work. In terms of Advocate Batoyi and Advocate Johnson, I think the issue is understanding what does appointment and commencement of work is. as I said, on the 10th of October 2024, confirmation of availability of the judge, and the judge saying, I'm willing to do. So meeting the requirement of the appointment has been done. What is missing is the regulation, which give effect to the judge doing the work. So once we get that, because I think my predecessor at that time thought that they would be able to get the regulations on time into Parliament, they have not been able to. Because if they had gotten that regulation, then the judge would have started last year. But because the regulations were not yet approved, that's why the judge can't start the work. Thanks.
Thank you, Honourable Minister. We now move on to question number 1273, which has been asked by the Honourable Tebukulu to the Minister of Defence and Military Veterans. The question is, given the disclosure by the Hawks that more than 2.5 billion rand in corruption and serious criminal cases across the South African National Defence Force, Department of Military Veterans, and the Department of Defence remain unresolved amid persistent non-cooperation, stalled investigations, and a collapse of accountability highlighted by the Auditor General and the Special Investigating Unit, what urgent national measures will her department take to enforce compliance and fast-track the long outstanding corruption cases, including the repair and maintenance project scandal at one military hospital in Tshwane, to ensure disciplinary action to safeguard the integrity of the defence system of the Republic? I have been informed that the Deputy Minister will be answering questions on behalf of the Minister, the Honourable Deputy Minister.
Deputy Speaker and honorable members, thank you for the question. With respect to parts A and B, I wish to clarify that while the honorable member refers to these matters as unresolved, they are in fact currently under formal investigation by the Hawks and the Special Investigating Unit. These investigations will culminate in recommendations for the Department of Defense and, where applicable, other institutions to act upon. It is also important to note that the value of the cases under investigation by the Hawks and SIU relating to the department is approximately 1.2 billion, not 2.5 billion as stated. During our recent engagement with the Portfolio Committee, both the Hawks and the SIU indicated that significant progress has been made, with several investigations nearing completion. Deadlines have been set, and once these reports are finalized, the department will be in a position to identify implicated individuals and implement appropriate corrective measures, including disciplinary action where recommended. Internally, the department has already taken steps to enforce compliance and accelerate the finalization of internal investigations. Clear deadlines have been instituted for boards of inquiry, and progress is now monitored through the management councils as part of the department's action plan to address findings raised by the Auditor General. Oversight by the Inspector General of the Defence Force is being intensified while the military police continue to liaise with the Hawks and SIU to provide all necessary support within their mandate. Furthermore, the leadership of the department has issued explicit instructions reaffirming our commitment to the timely resolution of all internal investigation. On the matter of one military hospital, which is indeed of great concern, the Hawks have confirmed that their investigation is nearing completion. As with all other cases, the recommendations from the investigating authorities will guide further action by both the department and the Hawks. Thank you.
The first supplementary question will be asked by the Honourable Tebukulu.
Thank you, Deputy Speaker. Minister or Deputy Minister, I'm sorry. What urgent steps will your department take to guarantee statutory whistleblower protection, and relocation financially support for defense personnel who expose corruption?
Well, the
The
Department of,
Honourable Deputy Minister, please proceed. I first recognise you.
are you recognizing me now?
I am recognising you. Please proceed.
Okay, ma'am. Thank you, Chairperson. The whistleblower protection policy is always there for all the departments. So in liaison with the state department responsible for that, I can assure you that we will not expose the whistleblowers. In fact, the Department of Defense and the police and Hawks and SIU are working in close collaboration on matters of that nature.
The second supplementary question will be asked by the Honourable Hala.
Honorable Deputy Speaker, can the Minister kindly update the House on the specific progress already made by her department since the matter was last raised in terms of 1, securing cooperation from all role players, 2, fast-tracking the outstanding Hawks and SIU investigations. Lastly, the concrete disciplinary and recovery steps now underway, particularly regarding the one military hospital repair and maintenance irregularities to restore public confidence to the SANDF. Thank you.
The Honourable Deputy Minister.
Thank you, Honorable Member, for addressing me as a minister. On a serious note, you will recall that last month we had the privilege of being briefed by the Hawks, by SIU, and also the Auditor General. So I can assure you that at least they said to us, unfortunately you were there, they told us that there is progress, they are seeing a progress. But I think what is going to be important for us as members of parliament is to keep on informing the public about the progress made. Perhaps if we have embarked on that, you wouldn't even want to ask the questions you have just asked now. So we need to improve the publicity part of cleaning the image of our defense.
Third supplementary question will be asked by the Honourable Nontenja.
Thank you, Honourable Deputy Speaker. Honourable Deputy Minister, what proactive and preventive strategies has the department put in place to rebuild the financial management architecture and prevent all these irregular, unauthorized and all that's happening, rather than addressing it as an after effect?
Thank you, Honourable Member. The Honourable Deputy Minister.
Thank you, Honourable Member. The Department of Defense has renewed or appointed a new audit committee, which is manned by the professionals outside the military. That audit committee, together with the department, has come up with an audit action plan to make sure that we address the queries, but at the same time, asking those who are in the procurement to be trained and also be screened and vetted to make sure that the mistakes of the past must not continue to haunt the Department of Defense. Thank you.
The last supplementary question will be asked by the Honourable Thring.
Thank you. Deputy Minister, the Auditor General has found that there's poor accountability and weak internal controls within the Department of Defense. And this is corroborated by the Hawks disclosure of some 1.2 billion in corruption and serious criminal cases across the South African National Defence Force, Department of Military Veterans, and Department of Defence. So, Deputy Minister, what specific steps will be taken to remedy the Auditor General's finding of poor accountability and weak internal controls, which have resulted in some officials and units obstructing investigations or withholding documents from law enforcement agencies? Thank you.
The Honourable Deputy Minister.
As I've just said, that there is an audit action plan which we are following, being assisted by the Defence Audit Committee as well as the AG. But what we must also be cognizant of is that we are dealing here with audit queries which are dating back as far back as 2006. So you can imagine the backlog which is there, but I am happy that the cooperation between the SIU, the Auditor General, National Treasury, as well as the Hawks, working together with our police, military police, we are making progress. And I hope that the NPA will make sure that at least they establish, even if you can talk of having established the special courts in order to accelerate these cases and to be finalized. But unfortunately, the police and the Hawks and NPA, sometimes they do raise their concerns that the NPA is dragging their feet. Thank you.
Thank you, Honourable Deputy Minister. Question number 1260 has been asked by the Honourable Sokopo to the Minister of Correctional Services. The question is whether his department has invoked Section 63A of the Criminal Procedure Act, Act 51 of 1977, during the period 1 April 2025 up to the latest specified date for which information is available, to alleviate overcrowding in remand detention facilities. If not, what is the position in this regard? If so, what criteria were applied in determining eligible inmates, and what measurable impact has he found it has had on reducing overcrowding levels nationally? The Honourable Minister.
Thank you, Honourable Deputy Speaker. Yes, the department does invoke Section 63A of the Criminal Procedure Act as amended, which empowers the head of a correctional centre to apply to a court for the release of an accused person or for the amendment of their bail conditions as a measure to ease overcrowding in remand detention facilities. The criteria is as follows. The inmate is housed in a facility wherein the head of a correctional centre is satisfied that the population is reaching such proportions that it constitutes a material and imminent threat to human dignity, physical health, or safety of the accused inmate who is charged with an offence falling within the category of offences for which a police official may grant bail in terms of Section 59 or referred to in Schedule 7, also has been granted bail by any lower court in respect of that offence, but is unable to pay the amount of bail concerned, and is not also in detention in respect of any other offence falling outside the category of offences referred to in the first paragraph. If I can give the statistics, in the first quarter of this year, there were 2,533 court referrals, 409 were successful. It gives us a percentage of 16.15% success rate. The second quarter, up till September, we referred 2,362 cases. We were successful in 506 cases, with a percentage of 21.42% success rate. In relation to the impact on reducing overcrowding, utilizing Section 63A, the department continues to collaborate with the Department of Justice and Constitutional Development, the National Prosecuting Authority, the South African Police Service, and the judiciary to facilitate the review of bail conditions and promote non-custodial options where appropriate. However, the ultimate decision regarding the detention or release of the remand detainees lies with the court and not with the Department of Correctional Services.
The first supplementary question will be asked by the Honourable Sokopo.
Thank you, Deputy Speaker. Thank you, Minister. In light of your response, may you also further indicate how the department intends to strengthen the consistent use of Section 63, subsection A, as a relief mechanism in severe congested remand centres? Thank you.
The Honourable Minister.
Well, as I said, Honourable Deputy Speaker, we can give the finer detail of each and every region where we referred certain cases, but the success and the way we do it is, as I have said, we refer it in the head of the correctional centre, of course, will do anything possible to reduce the overcrowding and will use this tool, and I call it a tool, for reducing overcrowding in the first instance, because then it is much easier, and it always must remember that you can only go into the court who had jurisdiction on that matter. So it's not that you can just randomly refer certain remand detainees to any other court. Thank you.
The second supplementary question will be asked by the Honourable Engelbrecht.
Minister, given the department's reported experience with Section 63A, what specific steps is the ministry taking to systemize its application in collaboration with the judiciary and the South African Police Service to ensure it is used as a primary tool for managing remand populations, and address any legal or operational impediments identified during this period that may have limited its broader and more effective implementation?
The Honourable Minister.
Thank you, Deputy Speaker. As the Honourable Member has said, we do collaborate with the Department of Justice. At least we try to have, say, on a quarterly basis, a meeting with the judiciary, where we also have the National Prosecuting Authority with us to see whether there are certain processes or administration that we can speed up, and that we also can bring under the intention of specifically prosecuting authority the problem of overcrowding. But we must always remember, in the end, even if you bring it, and as I said, let's take, for example, the first quarter, we came forward with 2,533 applications, but only 409 or 16.15% were successful, because it, in the end, lies with the presiding officer, whoever, whether it is a lower court or a higher court, but it lies with them. And that's why we also have meetings with the chief judge to see whether we can speak to other presiding officers to see how we can ensure that there is more, can I say, understanding for the overcrowding problem in our facilities.
The third supplementary question will be asked by the Honourable James.
Thank you, Speaker. Minister, laat ek maar mooi praat vandag. Would you agree with Action SA that South Africa cannot continue with a situation where our prisons face overcrowding of levels up to 220%, driven by foreign nationals whose upkeep is being funded by law-abiding citizens? Furthermore, is your department even engaging with DIRCO and the Department of Justice to explore mechanisms to recoup the costs from countries of origin and to strengthen our systems to ensure that our correctional facilities do not become bed and breakfast for foreign offenders? Thank you.
The Honourable Minister.
Thank you, Deputy Speaker. The honourable member is a member of the Portfolio Committee, and we had these discussions there many times, but let I reiterate again. Firstly, yes, we have a problem, and I said that we must do everything to see how we can deal with this problem. Unfortunately, the reality is that we only have so much space, and we are in a process to see that we can get some more facilities. I also want to state it very clearly that there's a special task team of the JCPS cluster, and they have regular committees, meetings, and they also make proposals what and how we can eliminate this overcrowding. When it comes to foreign nationals in our facilities, we talk about, say, 26 to 27,000 of them, and I am on record to say that we're in the process to see what we can do to repatriate them back to their countries of origin. And in the end, I would like to see that those people are sent back to their countries of origin. But unfortunately, it is an amendment of legislation, and the honourable member will know it's not as simple that you change legislation tomorrow. It's a process, but we will continue with that process.
The last supplementary question will be asked by the Honourable Swart.
Thank you, Madam Deputy Speaker. Deputy Speaker, the ACDP shares the concerns about the perennial problem of overcrowding, which negatively impacts on rehabilitation and places the safety and security of inmates and officials at risk. There are some 55,000 remanded detainees. It seems, however, that far more Section 63A applications are now being brought by the department, which is commendable. It is, however, Honourable Minister, as you indicated, that the department relies on the judiciary to make the final decisions. In that light, Honourable Minister, to what do you attribute the relative low success rate of 16.5% and 21.6% of the court applications that were brought, given that the cases only pertain to certain categories of offenders who have been granted bail but cannot afford to pay it? This particularly in light of the fact that it costs more than 400 Rand per day to house such remand detainees. Thank you.
Time has expired. The Honourable Minister.
Thank you, Honourable Deputy Speaker. I agree with the Honourable Swart of what he has said. I can also inform him that the number of remand detainees increased. They're about between 58,000 and 59,000 now. But unfortunately, in the end, it is the decision of the presiding officer, the magistrate, or the judge, whatever the case may be. And we cannot interfere with that. Of course, the honourable member knows that. But I think what he wants to say is, yes, it's costing us at this moment 463 Rand a day per inmate. And it is very costly to the taxpayers of South Africa. And we do engage, as I've mentioned, with the judiciary. I also spoke to the Minister of Justice and Constitutional Development, and from her side, she is also doing everything she can, and she does understand the problem, and we put our heads together to see what we can further do to ensure that we can use and utilize Section 63A in a more effective way.
Thank you, Honourable Minister. The next question is question number 1259 and has been asked by the Honourable Meshwe to the Acting Minister of Police. The question is whether the South African Police Service received a request from the Border Management Authority for certain powers that presently resides with the SAPS that must be handed over to them to make their work more effective. If not, what is the position in this regard? If so, which specific powers have been requested, and by what date will the specified handover take place? I have been informed that the Deputy Minister will be answering questions on behalf of the Minister. The Honourable Deputy Minister.
Thank you very much, Deputy Speaker. At the time of the deliberations of the establishment of the Border Management Authority, BMA, the transfer of certain powers and functions from the Minister of Police to the Minister of Home Affairs were requested. This included powers and functions in terms of the Explosive Act 1956, Act number 26 of 1956, the Firearms Control Act 2000, Act number 60 of 2000, and the Second-Hand Goods Act 2009, Act number 6 of 2009. It was argued that Section 97B of the Constitution of the Republic of South Africa, 1996, the Constitution, provides that the President, by proclamation, may transfer to a member of the Cabinet any power or functions entrusted by legislation to another member. The provision, therefore, authorized the transfer of power or functions from the Minister of Police to the Minister of Home Affairs. Legal advice obtained by SAPS, it concluded that the relevant powers and functions set out in the particular legislation could not be transferred. It was based on the fact that the legislation confers power upon and assign functions to members of the South African Police Services, SAPS, and not to the Minister of Police. Section 97 does not authorize the transfer of powers and functions from an official, that is police official, to a minister, that is the Minister of Home Affairs, only from one minister to another minister. Most recently, the BMA requested the transfer of power conferred upon a member of the SAPS in terms of Section 13(6) of the South African Police Service Act 1995, Act number 68 of 1995, to the Minister of Home Affairs. However, this request could not be agreed to based on the same legal interpretation. Thank you very much, Honorable Deputy Speaker.
The first supplementary question will be asked by the Honourable Meshwe.
Thank you, Deputy Speaker. If no powers can be transferred to BMA and they are expected to ensure that our borders that are leaking stop leaking, what is the advantage of having BMA with no powers that the SAPS has? Why does the SAPS ensure that the borders are sealed and we do not have the foreign nationals coming into the country as if we don't have borders? Because they don't have powers, and the legislation, as you are saying, is not allowing anybody to transfer powers to the BMA. Thank you.
The Honourable Deputy Minister.
Thank you very much, Deputy Speaker. The BMA is working together with the South African Police Service and also the South African Defence Force. And they've been working together even before it was formed. When it was launched in Musina, fortunately, I was there, and in terms of what could be done. So from the police side, we don't have the resources actually to transfer to BMA at the moment. And we are helping them to be able to get that resources from CARA so that they can be able to do their work. Until they are fully resourced, we will not withdraw any powers or anybody from the border. We'll make sure that we work hand in hand with them to make sure that our borders are safe. Thank you, Deputy Speaker.
The second supplementary question will be asked by the Honourable Muela.
Thank you very much, Deputy Speaker. Deputy Minister, in view of your response, can the Deputy Minister further clarify what measures are being taken to ensure that any transfer of policing powers to the Border Management Authority does not weaken SAPS operational capacity at points of entry, particularly regarding crime intelligence, organized crime detection, and cross-border traffic enforcement, as you have already clarified in terms of the act that you have stipulated? Thank you very much.
The Honourable Deputy Minister.
Thank you very much, Deputy Speaker. As I've said, it is not possible to transfer the police function, but it does not mean that as the police services, we are not able to do the act. We are working together very well, and we are making sure that organized crime and all the crimes that happen, we are helping each other. It's just that at the moment, both the BMA and the SAPS need more resources to be able to do their work effectively. I think also SANDF need their work so that we can be able to work together. So there is no way in which we can abandon that responsibility. We'll make sure that our country is safe and also we save the sovereignty of our country. Thank you very much.
The third supplementary question will be asked by the Honourable James.
Thank you, Speaker. Deputy Minister, year after year, government blames SAPS, Home Affairs or BMA for our collapsing borders. Yet the truth is, your government has left BMA with a staggering 2 billion shortfall, while SAPS clings to key border control powers it should have handed over a long time ago. In light of this chronic failure, will you admit that your department is directly contributing to the chaos at our borders, including unchecked illegal crossings, smuggling and trafficking? And can you tell this House why South Africans should believe any promises of improved border security when neither the funding nor the legal powers are in place? And finally, Deputy Minister, by when will SAPS complete the transfer of these operational functions to the BMA? Thank you.
The Honourable Deputy Minister.
Thank you very much, Deputy Minister. I think I must be able to explain this issue of the BMA and the 2 billion that people are talking about. And as I always said, you can't transfer from an empty cup. Fortunately, when the BMA was formed, it was when the Minister of Home Affairs was still Dr. Aaron Motsoaledi, and I was part of some of the discussion when it was. The aim of the BMA is to make sure that our borders are safe as much as the SAPS, as much as the SSA, as much as the SANDF. At the moment, as SAPS, we don't have enough resources. The police that we have at this moment are less than what we had in 2010 when we had the World Cup. And you know that the population have grown up. And we're trying as much as possible to bring more resources into the SAPS to be able to assist us. Fortunately, last week, 3,433 constables graduated from colleges to be able to do that. So there's no billion that must be transferred to BMA or officials, police that want to be transported to the BMA. The BMA have the opportunity to advertise for the police or people who can work as police to be able to apply, and they will have the budget to be able to pay them. So you can't take from an empty cup and be able to give to somebody else. We still have the responsibility in terms of 205 of our constitution, and we can't be able to comply with it if we give what we don't have to BMA. But as I said, we are working together to make sure that these shortcomings, we are dealing with it. The matter
Thank you,
is-
Deputy Minister.
Thank you very much.
The last supplementary question will be asked by the Honourable Ghana.
DM, I am listening and I'm trying to picture what really is happening. So let's say there's a criminal that the BMA flags or they get hold. You are saying that there's a close working relations with the police. How does that work? And maybe you can share with this House to say with the plane that landed with Palestinians, was SAPS involved in that standoff for, I think it was 8+ hours? And what was the role of the SAPS in that? Just in explaining these close working relations between BMA and SAPS. Thanks.
The Honourable Deputy Minister.
Thank you very much, Deputy Speaker. In terms of working together with BMA, last year on the 31st of December, 2024, I was working at Beitbridge together with SARS, together with Department of Rural Development. They were loaning us some drones, and together with SANDF and all others, we were able to get about 88 cars which were stolen and were about to cross the border. So we are working together and not competing to make sure that we deal with the border issue. In terms of the other question that you ask, I think it's not for me to explain. The person who must be able to explain will do so. Thank you very much, Speaker.
Thank you, Deputy Minister. I think the Honourable Ghana sneaked that last part of the question in. It is a different question. Honourable members, we proceed. Question number 1298 has been asked by the Honourable Breitenbach to the Minister of Justice and Constitutional Development. The question is, considering that during the National Summit Against Gender-Based Violence and Femicide, she made a number of commitments to combat the scourge more effectively, what tangible progress has been made with the implementation of the commitments, and what are the reasons that the criminal justice system continues to struggle with providing adequate protection and support for survivors? The Honourable Minister.
Thank you very much, Deputy Speaker. As we may know that many resolutions were taken during the Presidential Summit on gender-based violence and femicide, and I shall only focus on those relating to the Department of Justice and Constitutional Development. In the previous financial year, 19 sexual offences courts were established, and in this financial year, 16 courts are being established. We are officially opening one tomorrow at Botshabelo in Free State, and these are important as they help victims to be able to testify appropriately and have environment that is appropriate victim support or victim-based and survivor-based approach. And 40 courts are being upgraded this financial year to provide a catalogue of survivor-centered support services. Since 2022, the Tutuzela Care Centers were increased to 66, and it is our plan to increase the footprint with additional 4 TCC. This year in the APP, you will see 2. We've been able to work around finding resources to be able to add 2 more. The department has introduced a multi-sectoral 100 days challenge to reduce the turnaround time in the finalization of cases of domestic violence and sexual offenses. This year, again, we have given a directive for the service of protection orders by the clerks of court to issue within 24 hours from the time the order is received from the court and is being monitored through our APP and their performance assessments. 103 ad hoc intermediaries were appointed to support the current fully appointed team to ensure there are no cases being postponed due to lack of intermediaries in the sexual offences courts. And this year, I tabled in Parliament the National Policy Directives on Gender-Based Violence or Domestic Violence for prosecutors to ensure victim-centered approach by prosecutors. In the protection of vulnerable groups from April 2025 to October 2025, a total of 40,063 NRSO clearance certificates have been issued. The ultimate goal is to make the register public. We remain committed. The review of existing legislation is underway as a draft has been finalized and being currently consulted within the JCPS team. It's currently at the technical level. The following amendments to legislation has been done since the President announced the changes. The Prevention and Combating of Hate Crimes and Hate Speech, Act 16 of 2023 was signed by the President as per the resolution of the summit. Domestic Violence Amendment Act 2021, except for one section dealing with appointment of an administrator and repository for documents related to domestic violence like protection, the entire act has come to effect. Criminal Law, Sexual Offences and Related Matters Amendment Act 2022 has come to effect. Criminal and Related Matters Amendment Act 2021 has come to effect. We do want to say, Honorable Breitenbach and members, the fight against gender-based violence needs all of us. It needs the whole society. While we can do our part as the justice system, we do need families, we do need churches, we do need everybody to be able to raise their hands. We'll continue to do monitoring and evaluation on our part to ensure no one lags behind. Thank you very much.
First supplementary question will be asked by the Honourable Breitenbach.
Thank you, Honorable Deputy Speaker. Honorable Minister, how many prosecutors have been specifically trained to prosecute GBVF matters since 2022? And how many prosecutors have completed the aspirant prosecutors program at the newly revamped Bridget Mabandla Justice College since the rather expensive renovation thereof? Thank you.
The Honourable Minister.
My apologies, because this is statistics I'll have to verify, otherwise I'll mislead the honorable member. I do not have that information at hand. But what we do once we issued these directives, we requested that Advocate Boni train everybody in terms of these directives that we've issued. So all of those that have been done have been taken through the new directives across the country, especially those who are within the soccer unit. Thank you.
The second supplementary question will be asked by the Honourable Chotetsi. The Honourable Chotetsi. Is there anyone from the ANC who will?
Thank you, Deputy Speaker.
Please proceed.
One of the challenges of dealing with crime in general in GBV plus F in particular is for the need to coordinate the JCPS cluster. What measures are put in place to strengthen the coordination of the JCPS cluster? Thank you, Minister.
The Honourable Minister.
Thank you very much, Honourable Member. I can confirm that as JCPS, we work together and we are coordinating, starting with statistics. What we have done in April this year and eventually in May latest, we actually asked NetJoins to have a part that deals with gender-based violence as a task team, and it had about 7 work streams, specifically focusing on gender-based violence. Out of that, what we did first was to focus on statistics, because you'd find that each and every department or agency will have a different mechanism where they deal with statistics. So you'd have subs, when they capture their statistics, they will have their own way, and then justice and others. So we then reconstructed the whole process and asked that we seamlessly want to work on the numbers that can make sense. So that was done. Number 2, we had to have the case management. So we emphasized the importance that at a point where the case is, there must be a whole approach of what you have as a police or investigator, a prosecutor, and those that are supposed to play a role, so that they can be, if it's a social worker who must do a report or a doctor that must do a report, working together to be able to manage. And out of that, for example, when we did, and I did an oversight in Randburg Magistrate Court and looked at terms of the case management, we found that out of the case management process, because it's got everybody, and they were able to pick up that they had a backlog in Gauteng on the basis that there was no psychiatrist to treat the children, to evaluate the children. So they were able to do an intervention from the case management and able to respond. JCPS as a cluster has done 2 outreach specifically for gender-based violence. It was in Limpopo and in Mthatha in the Eastern Cape. This was to evaluate what is the standard in the police station, whether the rooms that the victims comes to or the survivors comes to is suitable. Go to the courts, evaluate the courts themselves,
Thank
the
you,
section
Honourable
offences
Minister.
and all that. So it went end to end. Thank you.
The third supplementary question will be asked by the Honourable Moshlala.
No, thanks so much, Minister. Minister, despite everything that you have said, ordinary survivors witness repeated failures, protection orders ignored, repeat offenders walking free, and police failing to act. If the justice system itself is failing, how can your summit commitment succeed without structural reforms to remove bottlenecks, corruption, and political interference at station and at court level? Thank you.
The Honourable Minister.
Thank you very much, Honourable Mhlala. The first issue in terms of protection orders, as part of responding, we've now made it possible for a protection order to be issued online. So you can apply for a protection order and it can be received on your WhatsApp. It's part of the issue. Even where we are looking for people, you find that we want to serve them and we can't find them. One incident, I think it's in the Free State, the magistrate had to find the person on social media because they kept on reaching out to that person and the person was not responding. So they went and plugged on their social media page that you've got this order on you, therefore respond. And the people actually got embarrassed and responded. So there are various mechanisms that we can say that needs to do. And understand the context that one woman raped is one too many. One child violated is one too many. So we can talk about statistics, but as long as there is a woman who is raped, there's a child who's violated, that's too many. So we need to create an environment where in a society that we protect these children, we protect the society. And gender-based violence, it has no political alliances. So there's no political interference because even myself, if I go and interfere, tomorrow it can be my child that is violated. So I can assure you there's no political interference. We understand as parents, as leaders in society that we've got to work together to fight gender-based violence in our country.
Thank you, Minister. The last supplementary question will be asked by the Honorable Mkwangu.
Well, thank you, Honorable Chairperson. Arising from your response, Honorable Minister, in KwaZulu-Natal, GBVF-related cases continue to face extensive delays due to outstanding DNA processing and court roll backlogs, particularly in eThekwini and Pietermaritzburg. What concrete steps has the department taken beyond policy commitments to ensure these cases are prioritized and not lost in systemic delays that deny survivors justice?
Honorable Minister.
Thank you very much. Ngiyabonga Babu Mngangu. Ngithanda ukukutshela ukuthi ngey-8 zika-December usekelwa mphathiswa lana or responsible for DNA sectors because it's not with us as Department of Justice, it's with the police. So bazabe bavula i-DNA center at KwaZulu-Natal eDurban. We've been waiting for that for a long time. We do think this is welcomed. Izosiza kakhulu kubantu bakithi elukuthi amacala wabo amile abomama bacela ukuthi bancedwe ngoba abantu babahlukumeza. So siyathemba ukuthi njengoba le center izovulwa i-DNA izoyenza ukuthi lamacala ahambe ngokushesha kakhulu. Ngiyabonga.
Thank you, Minister. Honorable members, question number 1263 has been asked by the Honorable Mokoena to the Acting Minister of Police. The question is, given the persistent public sentiment that the criminal justice system remains slow and unresponsive in gender-based violence cases, what measures has the South African Police Services implemented to improve frontline responsiveness by strengthening investigation capacity and addressing weaknesses in the handling of dockets ahead of and during the 16 days of activism for No Violence Against Women and Children campaign? The Honourable Deputy Minister.
Thank you very much, Honorable House Chairperson. On the 7th October 2025, the South African Police Services officially launched Operation Safer Festive Season, unfolding the 5 coordinated phases that combines high visibility policing, tactical crime prevention, intelligence-driven operation, and will be conducted alongside operational Channel 2 during the festive season deployments. Operation Safe Festive Season reaffirms the government's dedication to protecting South African and maintaining law and order during the festive season. The operation will focus on several priorities, crimes, and strategic threats, including gender-based violence and femicide and domestic violence act enforcement and compliance with protection orders. The SAPS, in collaboration with other governments, departments, especially the JCPS cluster and civil society organization, will continue to observe GBVF public education programs and awareness across the provinces, which include the 16 days of activism for no violence against women and children campaigns. These campaigns will include members of the detective services, which will do the following: a campaign educating communities on GBV and distribution of communication material and safety tips, imbies or roadblocks, crime prevention operation at hotspot areas, raiding and closing of illegal shebins, tracing of wanted suspects. The subs have prioritized the capacization of the detective services during 2025-26, including FCS unit through the placement of newly recruited students who have received the required specialized training, the re-enlistment of detectives who exited the SAPS, the return of trained detectives who were transferred or promoted outside the detective service environment. The Family Violence, Child Protection and Sexual Offense Unit is a specialized unit of which there are 176 geographically placed units that serve the 1,172 police stations countrywide, thereby aligning the placement of FCS units within the district. While the offices of various FCS units are not yet open, all, we are trying our best to be able to make sure that as we go to festive season, and you know that there will be a lot of abuse of alcohol and drugs, we make sure that they all functions. The 40 million that the minister announced during the announcement of crime stats is to make sure that we revamp the Minister of Police. We revamp the violent-friendly victims. Can I be protected, House Chair?
Are protected, Deputy.
Thank you very much. Cases of statutory rapes are traced by using SAP's crime administrative system, which is technology which provides a breakdown of specific types of crime as well as the status of the crime in terms of investigation process. At national and provincial levels, cases are being monitored by using SAP's crime management information system to monitor and advise on the criminal investigation processes. And the national and provincial offices also conduct visits to family violence and child protection units to assess performance and provide guidance on the efficient and effectiveness of completion of investigation processes. Thank you very much, Deputy House Chair.
Thank you, Deputy Minister. Deputy Minister, before I recognize the Honorable Mokoena for a follow-up, won't you just move the mic ever so slightly away from you? Most members are too far from it, but in your case, there's a bit of feedback, which I'm worried might be even taken to the broadcast. The Honorable Mokoena.
House Chair, I will take this question on behalf of Honorable Mokoena.
You're welcome.
Deputy Minister, further to your reply on the measures implemented to improve frontline responsiveness and strengthen investigation capacity in GBV cases, what steps have you been taken to ensure that these interventions result in measurable improvements, specifically in relation to reducing investigation turnaround times, preventing the recurring problem of missing incomplete dockets, ensuring consistent oversight of GBV cases beyond the 16 days of activism? Thank you very much.
Thank you, Honorable Deputy Minister.
Thank you very much, Honorable House Chair. Am I audible? Thank you very much. As indicated in my response, cases of statutory rapes will be traced, which provide a breakdown of specific types of crimes, as well as the status of the crime. And also the SAPS have implemented a national nodal point to monitor all reported cases of sexual offenses committed against women and children across the country. This nodal point assesses the status of investigation and advises on further action regarding specific investigation as and when required. Investigation officers within the FCS units are also encouraged to involve prosecutors in the investigation of complex cases to receive court-directed advice during the investigation processes so that we are able to achieve success. And also, we assess the performance, as I said, so that we can be able to do that. We have also re-enlisted other detectives that have left with experience to assist us in this matter. Thank you very much, Honorable House Chair.
Thank you, Deputy Minister. The second follow-up has been allocated to the Honorable Schikkerling.
Thank you very much, House Chair. Good afternoon, Deputy Minister. It really does seem that we spend a lot of time talking about GBV, but we don't get much done. What steps has the SAPS taken to prevent the loss and misplacement of dockets and the contamination of forensic evidence? And will you please provide us, Deputy Minister, with the latest data on DNA turnaround times and the size of the remaining backlog that we've got in South Africa? Thank you.
Honorable Deputy Minister.
Thank you very much, House Chair. Am I audible? It seems, am I fine? All right. Thank you very much, Honorable Schikkerling. In terms of the dockets, what subs have started, they've started what they call e-docketing, which is just, just, no, it's not electronic. It's just electronic, but also just for filing, where you are not able to see where your case is and what is happening and the feedback. So the system that we want to put on is to make sure that when there is a docket, you have a password like you have in your port or your bank or everything, where you can then log in and see where your case is in terms of your docket, not just a copy, but where it is in terms of the investigation. And when you are not satisfied, you are able to also lodge the dissatisfaction in that thing. So yes, we want to do that in terms of the technology. Yes, we are aware that there are dockets that have leaks, and in this process, we're trying to deal with the issue. But we want to ensure that, or ensure the public that we are aware of the issue and we know it is a problem and we are dealing with it. And we are not going to shy away that it is a challenge and we are dealing with it. Thank you very much.
The Honorable Abader.
Thank you, Chairperson. Honorable Deputy Minister, your reply still does not address the lived reality of victims. Can you clarify why SAPS continues to prioritize administrative compliance over operational urgency when frontline officers themselves admit they lack vehicles, manpower, and forensic turnaround times to respond to GBV cases? And what direct intervention will your department take to ensure that victims are not forced to return home to their abusers simply because SAPS cannot respond timelessly? Thank you.
Honorable Deputy Minister.
Thank you very much, Honorable House Chair. As the Minister of Justice have said, the GBVF issue is not an issue of police only. It's a whole society issue. Sometimes the police, unfortunately, we come after the act have happened. So as the community, we should be able to work together. We have started, like Thohoyandou is #1 in terms of rape cases, in terms of our stats. I have gone there. I've started working with the traditional leaders there, the church people there, the school children, everybody, to make sure that all of us take responsibility and make sure that the GBVF is dealt with thoroughly. It is not good to see the victims. I work with them every day. Sometimes you find them, unfortunately, not alive. Sometimes you find them mutilated. So it is very torturing, and sometimes it also involves some of our families. So it is not true that we are not doing anything, we are just talking. We are busy with the issue, like we are here today. We're supposed to go somewhere, but because we respect you and respect the people of South Africa, we came here to give answers. But we are busy, and that's why the minister was able to even allocate 40 million because of the stats to say, out of this top 30 stations, that shows that they're highest in terms of rape. What do we do to make sure that we deal with the sketch? So we call upon all of you from all political parties to assist us to deal with this matter, because it normally happens among people who know each other. Thank you very much, Honorable House Chair.
Honorable members, the last follow-up has been allocated to the Honorable Koza.
Thank you very much, House Chair. Deputy Minister, State SA has reported that there were 2,103 reported cases of births by girls between the age of 10 and 14 in 2024. Those are 2,103 clear cases of statutory rape in the country. And that number is only a tip of the iceberg in as far as this heinous crime against children is concerned. Why has the South African Police Service persistently failed our girl children over the years by refusing to open cases and investigate these Schedule 5 offenses that are widely reported by government institutions annually and in some cases quarterly? Why do our girl children not deserve protection and justice from the South African police? And Deputy Minister, if you can take us into confidence as to how many
Thank you,
statutory
Honourable
rape
Member.
cases have you tracked?
Your
on the
time has now
crime that
expired.
we've been talking about. Thanks.
Honourable Deputy Minister.
Thank you very much, Honorable House Chair. Thank you very much, Honorable Minister. This is the best question. Honorable Member. No, it's Honorable Member. This is the best question I received since I left college. I agree with you. It's just that sometimes we don't want to see the whole thing and also look at the small thing. I was once MEC of Education. In terms of the South African Schools Act, it said only relatives can be able to open a case when you are a relative to a child, even if you see that a child is violated in terms of your statutory right. But in terms of the Bella Act, that have changed to say anybody who witness what is going on in terms of the statutory rape, you are allowed to approach any police station and open a case without even consulting the parents. It's just that we don't see it, we just see one issue of it. This Saturday, we were having the Department of Women, Children, and People with Disability. We're having teenage pregnancy and statutory rape conference at Beachwood, and I was one of the speakers that were there. And I was happy that even men were there and being able to take responsibilities. Unfortunately, as I have said, there was a case also in Seshego where a 13-year-old gave birth. And I went there, I was at the forefront there and trying to make sure that we open the cases and deal with the matter. So we arrested the boy that he said raped her, only to find that the DNA did not match. And the boy have spent about a month in the police custody. So it means we have to pay money. So all of us must never allow.
Thank you, Deputy Minister.
Thank you very much.
Honourable
Order,
Members, question
Chair, House
number
Chair.
1. Yes,
She has not even touched a single question. It's clear. We said there are
Honourable
cases
Mkalipi.
that we need to be updated about. This is very serious. We're talking about the statutory rape.
Yes.
So she's
Thank you,
busy
Honourable
asking about
Mkalipi. It is
FC position.
Honourable
We need
Mkalipi.
to know about our girl children
Order.
raped here in this country.
Honourable Mkalipi.
No.
It is indeed a very serious issue, but that still doesn't
On a
give you the
point
right.
of order, Chair, I have my hand up.
Honourable Matthys, I'll come to you. Honourable Mkalipi, you know the rules. That was not a point of order. It's a point of debate. No. Let me just say this. Earlier this week, we dealt with a report of the Rules Committee. Previously, we as presiding officers has said, if you want a change in the rules to allow for an engagement because you feel the minister has not answered, change the rules.
Perhaps rephrase
No,
the
Honourable
question, then we
Mkalipi,
can get a
I've
different
dealt with the
response.
matter. No. Honourable Mkalipi, that was not a point of order. We're moving on. Thank you. No, thank you. Honourable Matthys on the virtual platform, please in
Yes,
future
Chair.
do not, no, hold on. In future, do not
Don't
unmute
address
and
our
start
members like
speaking.
that, Chairman.
do not unmute and start speaking before you have been recognized.
We are now being emotional for nothing, Chairman.
Honorable Matthys, you wanted to be heard. What is your point of order?
Yeah, Chair, my hand was up for a while, so that's why I asked to be recognized, because I thought you didn't see it. I do understand what the rules are. But Chair, it must be noted that this GNU government is failing us. They can't even answer a simple question about statutory rates.
Yes.
It's 16 days of activism. And we have
Honorable
a deputy minister
Matthys.
that's telling us about a case that they failed to ask a
Honorable
11-year-old or a
Matthys.
12-year-old a proper question about how many men
Thank you, Honorable
raped the
Matthys.
child. No, it must be noted. We are
Yeah, thank
reducing
you.
a very serious
Honorable
matter
Matthys.
to
Yes.
question time and whether
Order.
minister or
Honorable
deputy
Matthys.
minister can
Please,
respond
will the
to
table
a
please
question or
assist
not.
me to mute the Honorable Matthys? Honorable members, firstly, I've already dealt with the point of view as aired by the Honorable Mkalipi that the question was not answered. Therefore, Honorable Matthys, once that ruling has been made, it is final. It does not add value for you
Yeah,
to
Chair, I'm
repeat
calling
it.
an order on you because I don't
Yeah,
know how
thank you. Please mute the Honorable
days
Matthys.
of activism and you're doing
Honorable
that,
Matthys, order.
that you are failing.
Order, Honorable Matthys. Secondly, honorable members, the rules are
You
quite
are
clear.
failing the children of,
Honorable Matthys.
by allowing this nonsense.
Honorable Matthys, I'm going to give you one more warning. If
You
you
can
again
warn me all you
unmute
want. This is
without
about
being recognized, table staff.
a person. You can mute me all you want.
Honorable Matthys, if you do that one more time, I will ask that you be removed from the session. No, Honorable Mkalipi, you know. Okay. Honorable members, we have now dealt with this matter. We're moving on. Question number 1321 has been removed from the question paper due to the resignation of the Honorable Rekwana. Honorable Trollip, why do you want to be recognized?
Honorable House Chair, on a point of order, with a flood of resignations and expulsions of members from MKP, we are being prejudiced. We don't have an opportunity to have a follow-up on this question. I think it's a very good question. So the Deputy Minister is here. I'm sure he's prepared. Very late notice to withdraw the question. Let's proceed with the question.
No, thank
not
you.
a point of order, Mr. Chair.
Honorable Trollip, even if I order honorable members, even if I agreed with you, I'm not empowered by the rules to allow for it. Order, honorable members. Question number 1336 has been asked by the Honorable Niaus to the Minister of Defence and Military Veterans. The question is considering the remarks made by the Vice Admiral Mondele Bese regarding the state of the South African Navy and its defence capabilities generally, which is linked to a prolonged period of defunding the South African National Defence Force and a subsequent statement in reply to the Vice Admiral. What steps has she taken to deal with the deteriorating state of the Navy and the Defence Force? The Deputy Minister.
Honorable Chairperson, thank you for the question. I wish to assure this House that steps to address the challenges of the South African Navy and the broader Defence Force did not begin recently, but were initiated well before the approval of 2015 Defence Review. That document was thoroughly consulted across the Department of Defense, the Executive, and both houses of Parliament. As members, we will be aware the department has suffered cumulative inflation-related cuts amounting to 63 billion since 2017 financial year, which has significantly constrained our ability to modernize and sustain our capabilities. Despite these constraints, the department has consistently engaged with National Treasury, the Standing Committee on Appropriations, the Joint Standing Committee on Defense, and the Portfolio Committee on Defense and Military Veterans to secure support for rejuvenating prime mission equipment and modernizing the force. Honorable members, I can confirm that during the previous medium-term expenditure framework period, Treasury began providing targeted support for critical capabilities. This includes 700 million for mobility packages and technology enhancements along our borderline, as well as recently 1 billion allocated to extend the life cycle of 2 of our medium transport aircraft. In addition, the department is currently engaging National Treasury on funding for the Journey to Greatness, which is a 30-year strategic document designed to restore and rebuild Defense Force. As part of this engagement, we have submitted areas requiring urgent interventions, all of which now form part of the ongoing discussions between officials of the Department of Defense and Treasury, as directed by the both executives. Treasury is also assisting the department with personal rejuvenation measures. This support is intended to strengthen the Defense Forces training pipeline and ensure the development of a younger, fitter, and mission-ready cohort of soldiers within the medium-term defense program. Finally, most recently, the National Treasury and the Department of Defense provided a joint presentation to the Portfolio Committee on Defense and Military Veterans on these matters, which reflects the shared commitment to stabilizing and strengthening the SANDF, including the Navy. Thank you, Chairperson.
Thank you, Deputy Minister. Honorable Nias.
Honorable Deputy Minister, I'm not sure you want to carry the can for the follies and the rash actions of your minister. But I'll ask the follow-up question anyhow. Why is the Honorable Minister, instead of meaningfully engaging with the very serious concerns and frustrations raised by Vice Admiral Lubise, chosen to threaten him with disciplinary action? Instead of threatening Vice Admiral Lubise in order to silence him, should he not rather be praised for his courage and patriotism? Surely everything possible should be done to assist the Vice Admiral to name and shame the executive members who are promoting drug cartels and other criminal syndicates. In the context of what is revealed about executive members in the Parliamentary Ad Hoc Committee and the Matlanga Commission, surely these allegations must be taken very seriously. Thank you.
Honorable Deputy Minister.
Thank you very much, Honorable Kalne House. The Honorable Minister of Defense wishes to begin by affirming that within the defense establishment, across government and in Parliament, there are established platforms specifically designed to manage and ventilate the types of concerns raised by the Chief of the Navy. And she has already started the process to consult on that issue. But the key here, there are certain things which the General or the Admiral of the Navy, which we have been hammering in this house, related to, can you keep quiet, please? You're making noise.
Order, honorable members.
Now, there are...
Honorable members to the left of the Deputy Minister, please take your conversation outside.
Yes.
Honorable Lorimer.
Call the DA into order, Chair.
Yes, I am. Honorable Deputy Minister, please continue.
We cannot deny that some of these issues, if not all, which have been raised by the Chief of Navy has reached this institution for many years, that of defunding. We must also remember that in 1998, a decision was taken by this Parliament that we will no longer invest more on military security, but it will be more on social security. As a result of that, the Department of Defense suffered a lot. Recently, the Minister of Finance, you will recall, he briefed us together with the Portfolio Committee and revealed that, yes, they had defunded the Defense Force because they had to go and bail out state SOEs. So there are issues which we need to swallow our pride at some stage and decide what priorities do we want to have in this country when it comes to the security-related matters. And I hope that the State Security Council or those who sit in the State Security Council do discuss the security threat analysis, conduct a security threat analysis.
Thank you, Deputy Minister. The next follow-up is to be asked by the Honorable Legetwe.
Ke a leboga mmusa kgotla go motlatsa tona wa tshireletso le mekaubere ya ntwa. Can the DM confirm which established internal structures such as the Defense Staff Council and Military Command Plenary enables senior officials to raise funding and combat readiness concerns confidentially, and what recent directives have been given to all services to ensure full use of these channels instead of public statement, especially when we deal with matters of national security. It's not about a simple matter, it's about a national interest. Thank you.
Honorable Deputy Minister.
Thank you very much, Chairperson, and thank you to the Honorable Member, the Chairperson of our Standing Committee. We have what you call a military command, the Military Command Council, and the Secretariat Council, and Plenary Defense Staff Council. These are the bodies which bring together senior leadership of the National Defense Force. Recently, the department has reiterated to all services and divisions the importance of utilizing these platforms fully, both to maintain institutional integrity and also to ensure that funding and state of readiness of our defense force is attended to. I think I've answered your question. Unless you have a follow-up.
No, Deputy Minister, somebody else will ask a follow-up. The Honorable Shelembe.
Deputy Minister, the Chief of the South African Navy, Vice Admiral Mondel Lubisi, in his address at the gala dinner held in November 2025, he further touched on the serious allegations, and amongst those was an alarming allegation that the government department attempted to bring a foreign company to patrol South African waters, a move he characterized as a sellout. Can the Deputy Minister confirm if this move was due to prolonged defunding of the Defense Force? Which department and official was responsible for this move? And what is your policy on the privatization of South Africa core sovereign functions such as territorial defense? Thank you.
Honorable Deputy Minister.
The issue of the Commander of Navy is being handled by the Office of the Minister and the Commander of the Defense Force, who is responsible for the discipline of the SANDF members. Until such time that they have engaged him, we will be in a position as well to be able to respond to your question, because now if I attempt to address that question, it will be like I'm basing my answers on a high-level gossip. let us wait for the minister to come and brief Parliament on these matters. Unfortunately, she is in Mozambique currently with the president.
The last supplementary question will be asked by the Honorable Douglas.
Thank you, Honorable Chair. Honorable Deputy Minister, in your response earlier, you said that we are facing certain constraints in terms of the budget and in terms of being able to fulfill the mandate that you have. And the challenge is for us is that you are part of government who has the mandate to be able to instruct Treasury to take money and pay for maintenance and pay for petrol and for all other things. In the light of Vice Admiral's warnings, can the minister explain why repeated alerts from senior leadership in the department has still not tabled a credible turnaround plan with clear timelines and funding requirements to arrest the decline of the Navy and the broader defense force? And what immediate actions will be taken to prevent further degradation of critical maritime and landward defense capabilities and to force the executive and Treasury to take action for our people's safety?
Honorable Deputy Minister.
Honorable Chairperson, the word force implies another thing. So I've been there before. I don't want to go through that route again. But on a serious note, the Department of Defense Force has submitted the challenges facing the department to the National Treasury, to the Office of the President, and as a result, there is a committee which has been established between the National Treasury as well as the team from the Department of Defense. So as I've earlier on indicated, that these meetings, and recently rather, the Minister of Finance did brief the Portfolio Committee on Defense. So we are fighting, but as I said, since 1998, the paradigm shift to move away from the military security to focus more on social security has led to the department to be where it is today. Situation was aggravated by the monies which were taken from the defense to bail out SOEs. So that is the situation. We are not folding our arms. Navy is part of that. The same clarion call has been made by the Air Force, the Army itself, and so on. So we are trying to rectify the situation. As for forcing them, there's only one way we can do is just to bombard them with our memorandums and make use of any opportunity. And fortunately, the Portfolio Committee is behind us. They have been engaging their counterparts here in Parliament to save the defense force.
Thank you, Deputy Minister. Honorable members, question number 1267 has been asked by the Honorable Plaatjes to the Minister of Defence and Military Veterans. The question is, given the structural shortfalls in the compensation of employees' allocation and the reliance on reserve force overutilization to sustain current operations, what measures has the department implemented to manage personnel and operational requirements within the available budget, and what progress has been made in discussions with National Treasury to secure additional funding and prevent such challenges from escalating? The Honorable Deputy Minister.
Honorable Chairperson, with respect to parts A and B, I wish to inform this House that at the instruction of the Minister of Defense and Military Veterans, the Department of Defense and the National Treasury have established a joint technical team. This team brings together officials from both departments to develop sustainable modalities that align our deployable human resource requirements with our operational obligations within the constraints of the current compensation of employees allocation. Furthermore, following the engagement of this joint team, and guided by both executives, the department has incorporated a set of urgent interventions into the medium-term expenditure framework. These interventions are intended to stabilize personnel management, address immediate cost pressures, and support ongoing discussions within the, with the National Treasury to secure the additional funding required to prevent these structural challenges from escalating. I thank you.
Honorable Plaatjes.
Thank you, Honorable Chair. Deputy Minister, now that you are saying that there's a team that is working on these matters in your department, this year, this financial year, what successful costing containment have you put in place as the department to optimize the spending on the compensation of employees, the budget thereof? Secondly, Minister, now that you've got some commitments from Treasury on some of your shortfalls, how are you going to see yourself structurally make sure that those funding is sustained and you don't overspend it on the regular forces and also the overutilizing of reserve forces? I thank you, Chair.
Honorable Deputy Minister.
This department, when it comes to issues related to deployment, relies heavily on this unit. And as a result of that, we have also included the directive of the President that the Department of Defense must be given more monies to rejuvenate the Department of Defense, because the reserves are the ones who are deployed in operations. On the other hand, we are trying to address the question of exit strategy, but it requires a lot of money. Exit strategy will allow those who are 51, 48, who are still troops, but they can no longer be fit to be deployed in the operation. We have also requested the National Treasury to give us money to recruit, at least in the next year or two, at least to recruit 10,000. But we understand the national fiscus that at times they have other priorities, but we are working around the clock to address the issue.
Thank you, Deputy Minister. Honorable members, before we move on, because I want to recognize the Honorable Shelembe, please be reminded that the use of cell phones within the House is not permitted. The Honorable Shelembe.
Bambe. Police.
Honorable Shelembe.
Deputy
Police.
As in the recent years, the Department of Defense continued to receive qualified audit.
For the honorable members, I don't think the Deputy Minister will be able to hear the question. Honorable Shelembe, please speak into the mic.
Deputy Minister, as in the recent years, the Department of Defense continued to receive qualified audit opinion from the Auditor General for 2024 and 25. And amongst the causes for the repeated qualified opinion is the material persistent misstatement on the basic salaries, housing allowance, and deprivation allowances, which made it impossible for the AG to determine the full extent of overstatement on compensation of employees. Can the Deputy Minister, given that the Department of Defense continues to receive qualified opinion, more especially on the compensation of employees, how are you going to motivate the National Treasury to give more money for compensation of employees once your department cannot account on its allocated budget when it is required by the Auditor General to do so? Thank you.
Deputy Minister.
Honorable Chairperson and Honorable Member, we are in agreement with the Auditor General that we will always receive these qualified reports, especially if we are not funded adequately, because what we are doing currently, we are like robbing Peter in order to pay Paul. In terms of the regulations, if you do that, you will be penalized. But if you look at issues like the devastation caused by the climate change, the support we are giving to the police, some of these, and also to ESCOM, some of these monies are not budgeted for, but they appear at the end of the day to be unauthorized expenditures because we cannot fold our arms and say there's no money. So what is needed now in future is that if, for instance, the Defense Force of South Africa is to be deployed elsewhere, the National Treasury should be informed by the President, and that the budget will cost such an operation, and that the budget is allocated. For us in this parliament, you approve, okay, yes, you can deploy the Defense Force members. And then when we go back, we find that we don't have enough money. So and then we go and take money somewhere, including the money which is earmarked for the reserves. So we need to change the
Thank you,
situation
Deputy
around.
Minister. The Honorable Douglas.
Thank you, Honorable Speaker. Given that the Defence, Honorable Deputy Minister, Force is already struggling with shortages in funded posts and an overstretched reserve force, what concrete backup plans does the department have if National Treasury refuses to increase the compensation of employees' budget, specifically to ensure that border safeguarding deployments continue without interruption? Our peacekeeping missions remain fully staffed and compliant with international obligations, and internal security support operations were not weakened in moments of national crisis. Thank you.
Honorable Deputy Minister.
Well, we are not going to mislead this House, Honorable Member. The Department of Defense is engaging the Department of National Treasury on the instructions of the President, who said, let us move away from 0.56% of the GDP to 1.5% of the GDP. So we are working on that mandate. Then if the National Treasury would refuse to adhere to that directive, then we will have no option but to come back to Parliament and say, notwithstanding what the President of this country is saying, there are people who are defying the President in order to fund the defense force of this country, which is compromising the security of South Africa.
The last follow-up is to be asked by the Honorable Ghana.
Naken samtramastul. Nge but Sasha and Lasha Olobs. General. So I want to check, when was your last engagement with the reserve force? And what is your assessment of the current state of the reserve force and their training needs, considering that we are utilizing them more than we should ordinarily be utilizing them? Thanks very much.
The leadership, Honorable Member of the Reserve Force, form part of these council structures I've outlined earlier on. They have submitted their requirements. Even last year, before we submitted to National Treasury as well as to the President. Yes, they are part of the leadership. We are aware about the problems, but like the Navy, they are also suffering, like the Air Force, like the Army, where, for instance, you have a defense, you deploy people, and then there are no tents. What are you expecting them to do? So we need to make sure that the priorities in this country are put correctly. Thank you.
Honorable members, question number 1301 has been asked by the Honorable Cameron to the Acting Minister of Police. The question is, with reference to his commitment to eliminate DNA backlogs and considering that rape and murder cases continue to stall in the system, what is the current total number of DNA backlog cases, and by what date will the South African Police Service guarantee a sustained turnaround time of under 30 days for new DNA samples? The Honourable Deputy Minister.
Thank you very much, Honorable House Chairperson. Thus far, in 2025-26 financial year, the laboratory have already received 303,728 case exhibit entries and already finalized 296,288 case exhibit entries. The biggest contributor to the high number of entries is intelligence and first out principle against date of exhibit delivery in the laboratory and loaded into the National Forensic Database for investigative purpose to establish lead serial offenders and is processed. A total of 212 statements generated in 2024-25 end of quarter two was 27,856, and in 2025-26 at the end of quarter two was 23,800, of which 10,815 were rape related and 2,364 murder related. Since the establishment of the NPA SAPS project, the committee ensured that prioritization of cases and non-withdrawal of cases due to a lack of DNA reports, and there is no backlog of GBVF and any other DNA-related cases. A total of 56,213 GBVF-related DNA reports have been successfully issued. In the financial year 25-26, as at the end of 30 September 2025, a total of 2,852 GBV-related reports has been issued, while NPA only formally requested 175 cases to be prioritized. The Forensic Science Laboratory is continuously experiencing high influx of cases due to heightened police strategies on the fight against crime. However, the human capacity within the laboratories is declining. The infrastructural deficiencies are a hindrance for the laboratory to function optimally, deteriorating state of facilities. There is lack of building maintenance contract for FSL laboratories, with the exception of the Eastern Cape laboratory, which is accommodated in the Department of Public Works building. The National Department of Public Works and Infrastructure have secured an estimated budget for procurement of vehicle for maintenance and repairs on matters relating to infrastructure in Pretoria, also Arcadia Laboratory, which commenced in April 2025 for a term of 36 months. The rotation of KwaZulu-Natal members, since the laboratory have not been fully functional to other regions, inflated the budget, and this was necessary to ensure that the institution complied to value for money on salaries paid monthly. However, plans are in process to resolve this challenge as the alternative accommodation currently is underway. And I'm happy, Honorable House Chair, to announce that the laboratory of KwaZulu-Natal, we're going to open it officially on the 8th of December 2025. Thank you very much, Honorable House Chair.
Thank you, Deputy Minister. Honourable Cameron.
Thank you, House Chair. Deputy Minister, I want to understand, has the DNA backlog been resolved or not? And if so, or if not, why not? And by when can we expect for the total DNA backlog to be resolved? Thank you, House Chair.
Deputy Minister.
Thank you very much, House Chairperson. The person who was asking question is our chairperson of the portfolios and knows what the answers are. In terms of the budget, we are not able to have laboratories in 4 provinces. Limpopo, we don't have, Northwest, Northern Cape, and Free State. So at least for this financial year, we have prioritized KwaZulu-Natal, which we said we are opening on the 8th of December. And also Mpumalanga, we are doing what is called e-laboratory, where we are using technology to be able to do the matter. So as soon as the chairperson help us to get more money to be able to deal with the 4 outstanding, I think we'll be able to have the turnaround as much as possible. But it's also important for me to mention that in terms of the GBVF cases, there is no backlog at all, and we don't agree with the backlog. Thank you very much.
The second supplementary question is to be asked by the Honorable Klute.
Thank you, Honorable House Chair. Honorable Deputy Minister, considering the impact of the delayed DNA results on case finalization, can the Minister indicate what operational thresholds the South African Police Service has set to guarantee that all forensic laboratories consistently meet the 30-day turnaround target? Thank you.
Honorable Deputy Minister.
Thank you very much, House Chair. As I said, unfortunately, we all depend on the National Department of Public Works and Infrastructure for all our infrastructures. So for the 4 laboratories that we would need, that's why we depend on the Department of Public Works. And as all of us knows, there's a lot of backlog, and also in terms of building the police stations, because Public Works don't have the requisite capacity. But also as subs, we are looking at alternatives of what we can do in order that we can be able to build our infrastructure that needs to be built so that we can be able to do that. But as soon as we get that, the 4 priorities are the laboratories in the 4 provinces that don't have the laboratories. Thank you very much.
The Honorable Abader.
Thank you, Chair. Minister, Deputy Minister, families sit in courtrooms shattered because rape and murder cases collapse, not for lack of truth, but because DNA results never arrive. Survivors are forced to relive their trauma for months and even years after, while critical evidence sits gathering dust in laboratories your department has repeatedly promised to fix. How do you justify a reality where a child's dignity, a woman's safety, and a family's justice are held hostage by a backlog that should no longer exist? And will you commit to an urgent, transparent, and enforceable turnaround plan with public reporting to ensure that no victim's case ever again dies on a laboratory shelf while her perpetrator walks free? Thank you.
Honorable Deputy Minister.
Thank you very much, Honorable House Chair. The SAPS has prioritized, as I said, the analysis of the GBVF related cases as part of projects that have been established with the NPA so that we deal with the backlog and that we don't have backlog in that regard. So a total of 53,361 GBVF related cases, including statutory rape cases, have been prioritized, and the DNA reports have been successfully issued as indicated as follows. In 2021-22, 7,611, 22-23, 20,492, 23-24, 16,606, 24-25, 8,652. And that's why I'm saying to you, as we add in Mpumalanga laboratory and also the one of KwaZulu-Natal, we'll also be able to deal with other backlog. But in terms of the GBVF and the statutory rape, we have that NPA SAPS project. We don't have any backlog at all. The problem is just the enrolling of the cases on the court roll, because it depends on the court when it is enrolled. But there is no backlog in terms of the GBVF and in terms of the statutory rape. Thank you very much, Honorable House Chair.
Honorable Koza, you may ask the last follow-up.
Thank you very much, House Chair. It's very disappointing, Minister, to sit here and hear you giving such a very misleading response in terms of the backlog that we're experiencing in the country, more especially on statutory rape and on the Kwekwe case. Can you please, as you respond, give the nation confidence on the response on the Kwekwe case, Minister. Deputy Minister, we have observed the intensified and deliberate effort at breaking down state institutions in order to allow for the outsourcing of these services to private sector. ESCOM has until recently deliberately run down in order to allow independent power producers to take over. SAA was deliberately collapsed in order to hand over our skies to private companies. Dinel has been collapsed in order to allow private arms manufacturers to hog that space. The collapse of the South African Police Service Forensic Lab is also a deliberate attempt to hand over this critical service to the private sector. What guarantees have you put in place that work, and that work will be done to give
Thank you,
deliberate
honorable member.
justice at the forensic lab without outsourcing these
Thank
critical
you.
state functions to private labs?
Order,
But listen, comrade.
order. Honorable Deputy Minister.
Thank
Honorable Deputy Minister, your microphone is not switched on.
Thank you very much, Honorable House Chair. In terms of the outsourcing of ESCOM and others, I would not know what that is all about. But in terms of our police station and also our lab, as I said, they are done by the Department of Public Works and Infrastructure. And I said, where we are, only 4 are left. And in terms of our police station, we had 1,164 in the last financial year. Now we have 1,172, which means some are completed. We are not able to increase as much as we would because of the constraint of the capacity in public works. So yes, we might be want to partner with various people to be able to complete, especially the laboratory. So I can't come here and sit here and said, we want outsource or won't source. But if there is a need and there is a problem that we need to address, we will do that based on the analysis that we would have done, based on the cost analysis and all other things. And in terms of the Kwekwe case, I'm shocked that, Honorable House Chair, we can come here in public and speak about children that are raped by ages. So
Always
I'm
shocked
not
and surprised.
able to do that because the
Order, honorable members. Give the Deputy Minister a chance, please.
Be shocked.
Order.
Acknowledge. She can't be shocked.
Order.
You are shocked and
Honorable,
surprised.
honorable
Give the
member.
public answers.
Honorable Koza, you have not been given permission to switch on your mic. You've asked a question, the Deputy Minister is responding. Please give her the platform. Honorable Deputy Minister, please proceed.
Yeah, so we have referred the matter for prosecution as they have to deal with the matter as the Department of Justice and all other things. But it's not with the police. So
Order.
can we be protected, Honorable?
Yes, no, honorable members, we can't have that. Afford the Deputy Minister the opportunity to respond. Order. Order, honorable members, but what's the use of having a question and answer session if the minister isn't audible?
We will heckle back. We have the capacity, but will not. So yes, we have the capacity to do that, but we respect the Honorable House. We respect the House Chair. We will not do that. So, Chair, as I said, that case is referred because it's a minor which need to be protected. It's referred to the Department of Justice and they are dealing with the matter. And as soon as they are ready, they'll be able to give answers to the public. Thank you very much,
Thank you.
Honorable House Chair.
Honorable members, question number 1270 has been asked by the Honorable Chabane to the Minister of Home Affairs. The question is, given that one of the challenges with regard to migration is that persons enter the Republic legally and later their status changes to illegal, as they may have exceeded their legal stay in the Republic, and that this will obviously defeat the whole object of dealing with illegal immigration, how will the Border Management Authority address the specified challenge? The Honourable Minister.
Thank you very much, Honourable House Chair and honourable members. First to indicate, Chair, that the BMA, as well as Home Affairs, have established processes in place to declare people who overstay as undesirable. In the case of a person who overstays for a period not exceeding 30 days, the entry ban is for a period of 1 year. In the case of a person whose overstay exceeds 30 days, they are declared undesirable and are banned for a period of 5 years. Now, Honourable Chair, traditionally the biggest challenge, and it's one that I've identified before this House before, the biggest challenge in this regard and in our capability to detect overstaying in a timeliest manner has been the lack of biometric and digital information recorded for foreigners. That is something that is now being changed through the electronic travel authorization, which is currently being rolled out in phases. The ETA records biometrics and other information for every foreigner who obtains a visa and enters South Africa, which will significantly enhance the capacity to proactively detect visa overstays. Once this is fully rolled out, the ETA will enable the BMA and the Department of Home Affairs to automatically detect when a visitor has failed to exit the country on time, because their facial biometrics are recorded both when they enter and when they exit. That is the end state for the ETA that we are building, and that will enable us to do things like directly contact overstayers and significantly enhance the capacity to proactively detect and enforce deportations and those undesirability orders in cases of visa overstaying. Thank you very much, Chair.
Thank you. The Honourable Chabane.
Thank you, Minister. Noting your responses, the House has made significant progress since the 5th and the 6th term initiating and passing the bills, BMA Act and OSBP. This is a significant step in responding to the concerns of South Africans about our security in our country. However, the border fence has been a thorn for a period of time, and this was observed recently by the Joint Standing Committee of Defense. Can the Minister update the House on the outcome of the investigation about the fence in Beitbridge and the plans to cover the 4,750 radius throughout our land port of entry? Thank you.
Thank you. Honourable Minister.
Thank you, Chair. It's a slightly different question from Honourable Chabane, but I'll try to give it a shot, as the original really refers to overstaying. But I think, firstly, the legislative reforms that the Honourable Member refers to are indeed very important. And there are a number of others that are also on the way through the process. That will include the revised white paper on immigration, citizenship and refugee management, which will really enable a lot of these mechanisms that I've just spoken about to be used more effectively. There's also the digital ID policy that is under development by the Department of Home Affairs that will enable us to have those biometric stores for foreigners in exactly the same way that we already have for South African citizens, so that if someone is detected on a camera, we actually have a database against which they can be matched, and that we're able to bring that level of automation and control to the immigration space. I think as it relates to the border environment and the border fence, this is obviously an issue that has been vexing for a long time, also because it cuts across the mandates also of Department of Home Affairs, BMA, as well as Public Works and Infrastructure, and also even the Defence Force. So this is something that requires really joint and coordinated action. It is not something that sits at all within the funding capabilities of the BMA at the moment. I think the Honourable House is aware of the significant underfunding of the BMA as a relatively new entity, and there is not a funding allocation in this regard. So it will have to be something that is done collaboratively with other departments. But I think in the meantime, what we are very much focused on is using technology to improve surveillance in the border environment, whether it's things like drones, body cameras, other surveillance technology that is making a difference on the ground at some of these ports of entry. But of course, if there is a greater investment of resources, both
Thank
in
you,
physical
Minister.
infrastructure and technology, we can do more. Thank you.
Thank you. Honorable Ngubane.
Thank you. Thank you, Deputy Chair. Minister, shouldn't people who have overstayed their visit in South Africa be blacklisted and fined higher penalty fees since they've breached the laws of the country by overstaying? Why is South Africa's penalty of visa overstaying breach so weak, considering that South Africa has a huge problems of illegal immigrants, and overstaying is one of the challenges being used many times for people to stay in South Africa, except for unforeseen circumstances beyond the applicant's holder's control?
Honorable Minister.
Thank you, Chair, and to the Honorable Ngubane for the question. Well, firstly, of course, these are legislated provisions, so they operate within a certain legal framework, but there is blacklisting. So as I mentioned in the original response, if someone overstays for less than 30 days, they are effectively blacklisted for a period of 1 year. If they exceed that 30-day threshold, then they are blacklisted for a period of 5 years. In the past, there has been mechanisms around fines, but they proved very difficult to enforce. So what we are currently looking at is whether we could combine, indeed, as the Honourable Member says, some form of blacklisting or undesirability status with fines. But we want to make sure that it's something that's enforceable, because we don't want the Auditor General to say that there's a system that cannot be implemented here. So it is something that we are currently looking at, but certainly there is strong enforcement where these are detected. The bigger problem is with the detection, as I mentioned. And I think that's where the ETA is really going to strengthen our hand. And I think finally to mention, there are some of those inadvertent cases where you'll find that someone has a flat tire or a medical emergency on the last day of their visa validity. And so there is a process in place for them to appeal once they have been declared undesirable. Thank you, Chair.
Thank you. The third supplementary question will be asked by the Honorable Marchi.
Thank you, Honorable Chairperson. Honorable Minister, how will the Border Management Authority enhance coordination with Home Affairs to strengthen internal controls, such as real-time data sharing, exit entry, tracking, and compliance alert to prevent illegal admitted visitors from lapsing into irregular status? If not, why not? If so, what are the relevant details? Thank you.
The Honorable Minister.
No, thank you, House Chair, and Honourable Marchi, you are absolutely right. That is central to what we are doing, is coordination between the BMA and Home Affairs. So to give you a concrete example of how important this is and how seriously it is being taken, if you look at how the ETA operates, and in fact how the visa system operates, it is the Department of Home Affairs that grants someone permission to enter South Africa, whether that's as a tourist or a student or anything else. And then it is the BMA that uses that permission, whether it is in the form of a traditional visa or in the form of the ETA, to then process their arrival when they come to South Africa. So by its very definition, these systems are integrated. There are other systems like the Advanced Passenger Processing System, which also is involved in the clearance of these passengers or travelers to South Africa. So it is an entire ecosystem. And that is really why we've taken an approach of referring to this as the Home Affairs ecosystem, so that we indeed don't have the development of silos in a space that is inherently based and reliant on that kind of coordination. So I can certainly report to the House that that is happening as it relates to the ETA. It is built in from day one, and it is something that we will continue to expand to make sure that we leverage off of both the Home Affairs capabilities and the BMA capabilities as we move forward to build that automated entry and exit system that the Honourable Member refers to. Thank you, Chair.
Thank you. Honorable Nontenja, you may ask the last follow-up.
Thank you, House Chair. South Africa continues to face significant challenges in migration management. These realities highlight the urgent need for a strengthened, coordinated, and sustained enforcement capacity across the country. Honorable Minister, what progress has been made on the biometric movement control system, and how will it improve the detection of overstayers, repeat border offenders, and those exploiting gaps in the current movement control processes?
Thank you, Honorable Minister.
Thank you, Chair, and to the honourable member for the question. Just by way of quick background, the Electronic Movement Control System, or EMCS, was built in 2010 around the Soccer World Cup at that stage, and it was rolled out at ports of entry at that time. It is really based upon the passport as the fundamental identifier. Then, subsequent to that, in recent years, there was an attempt to replace that with what the honourable member refers to there as the Biometric Movement Control System, or BMCS. Unfortunately, that rollout was not a success. One of the reasons is that it was based on fingerprints. And honourable members can imagine how long it would take you if you're standing at an immigration queue and every single person has to do 10 fingerprints one by one. There were also issues around system stability. So what we have done now instead is to move to facial recognition. You will remember, Chair, that not long ago, the thumb fingerprint was the key to unlocking something like a cell phone. But these days, it's all based on facial recognition. That is because that has really become the key a credential that's being used around the world for security purposes. So instead of the BMCS and all the challenges that we experienced there, the ETA is linked to an EMCS 2.0, which is effectively building on the infrastructure that has worked successfully in the form of EMCS, but now adding those facial recognition functions and integration with other verification systems that indeed is going to make the kind of difference the member is talking about. Thank you.
Thank you. Honourable members, question number 1256 has been asked by the Honourable Ghana to the Acting Minister of Police. The question is, what is the total number of murder cases that have been reported and solved in 2024? The Honourable Deputy Minister.
Thank you very much, Honorable House Chair. 24,692 murder cases were reported during the 2024-25 financial year. 15,130 charges of murder have been solved during the 2024-25 financial year. These charges include suspects charged, cases finalized as guilty, cases where suspect is deceased, and alternative dispute resolution. It should also be noted that the number of charges solved during the 2024-25 will also include cases that were reported prior to 2024-25 due to the nature of the case docket management process. Thank you very much, Honorable House Chair.
Thank you, Honourable Ghana.
So, Minister, to the last statement that you have issued, so the essence of my question is to say, all right, what are the cases? So if you take the 15,000 that you have listed to say that were solved in 2024, how many of those relates to the murders committed in 2024? Because one of the big issues that we do have, as you'll know, is the detection rate of murder cases in South Africa, which is very low, extremely low. I think it's sitting at 11%. So according to the annual report, by the way. So I would have loved to ask the minister or the acting minister to say, since his arrival, maybe you can answer because now it's a new broom. Since the arrival of the new minister, what are the strategies or tactics that have been introduced to improve the murder detection rate So if you could just respond to that. And if none has been introduced, you can also say that nothing has been introduced as it is. Thanks.
Thank you, Honorable Deputy Minister.
Thank you very much, Honorable House Chair. I'm not sure what the member is referring to when he said non-detected murder case, because I was just giving the figures here. But also to say the Minister of Police is Professor Firoz Kachalia. So there's no, I'm the Deputy Minister, I'm not the Minister. But as the SAPs were able to get detective, as I said, those that have retired to come and be able to assist us. I also said last week, 3,433 new constables graduated, and we have put more feet on the ground to be able to assist with such. And I also said we have increased our police station from 1,164 to 1,172. I've also said 2 laboratories are going to be opened in this year, the Mpumalanga one and the one in KwaZulu-Natal. So we'll be able to deal with these cases of murder. Thank you very much, Honorable Chair.
Honorable Moela.
Thank you, House Chairperson. Deputy Minister, in light of the figures provided, can the Deputy Minister further indicate what targeted interventions will be implemented to improve the murder detection rate, particularly in high burden stations, and whether additional investigative capacity, forensic turnaround improvements, or specialized units will be deployed to address the gap between reported and solved cases? Thank you very much.
Honorable Deputy Minister.
Thank you very much, Honorable House Chair. The SAPC has PSF embarked on a specific project to capacitate the detective service capacity in 2025-26. This capacitation, which will involve the placement of approximately 4,000 personnel members as the detective service by the end of 2025-26 financial year, will include the appointment of former detectives who have left the SAPs on a contract basis, the re-enlistment of the SAPS members who have specialized detective services training from other environments in the SAPs back to the detective service, the filling of vacant posts through lateral transfers, and the placement of entry-level constable which have received the prerequisite training at the detective service. In addition, 353 contract workers to assist with the backlog of case docket older than 2 years, murders included, and 1,536 students who have just passed out and will now do their workplace exposure before placed at detective services units. 200 re-enlistment are to be placed in the newly established forensic investigation leads unit, and an additional 1,000 members are projected to join the detective services through lateral transfers. The following interventions are and will continue to be implemented to address the detection rate for murder. 1, murder cases with forensic investigative leads are followed up. Tracing operation focusing on wanted persons, particularly those wanted for violent crimes, are conducted. Performance review meetings are conducted quarterly to assess the performance and initiate corrective actions where required, and the capacization of the murder and robbery units. Thank you very much, Honorable House Chair.
Thank you.
House Chair, what's the point of this exercise if the minister, the Deputy
Honorable
Minister
Member,
can just read?
Honorable Member, just
question
pause
word by
there.
word?
No, Honorable Member, just
I was
pause there.
sharing these questions
Honorable
before coming to
Member,
this house.
pause please. Put up your hand. Okay. You don't want to. Please don't unmute and speak again without raising your hand. Honorable Mkalipi, why do you want to be recognized?
Chair, is the ANC giving the ministers follow-up questions? Because she's reading the whole paragraph. How does she know?
Thank you, Honorable.
So no, you're rendering this service very useless. This is very useless.
Thank you, Honorable.
So she can't read our questions because we don't give it to her. But
Honorable-
when is the ANC? No, Chair.
Thank
I
you.
know this.
Honorable
No.
Mkalipi.
Aye,
Thank you.
so we must not have this kind of a questioning and answer.
Thank you. Honorable Mkalipi, that's technically not a point of order, but let me say this. Order, let me just say this. Let me say this to the Honorable Deputy Minister. Essentially, this follow-up was the same one the Honorable Ghana asked. And then you spoke off the cuff. It doesn't give a good impression if a member of your own party asks essentially the same question and then you're able to read. In that sense, I must agree with the honorable members.
Yes.
Thank you.
Yes.
Order, order.
And
Honorable
she
Cam.
said she's speaking on behalf
No,
of the
Honorable
SACP.
Mkalipi, don't
For-
now
Voorzitter.
overreach.
Voorzitter,
Order. Honorable
Voorzitter.
Kwankwa on the virtual platform. Why do you want to be recognized?
yeah, Norman, maybe the ANC should not be allowed to ask follow-up questions to their own
No,
ministers.
Honorable Kwankwa. Order. Honorable members, let's move on. Honorable Cameron.
Deputy Speaker, Acting Speaker, my hand is up. It's paining now. So long it's up.
Honorable Reddy, unless that's a new point of order, I've dealt with the previous one. Why do you want to be recognized?
Thank you. Your ruling, I just want to commend you on the ruling, but just state that this whole process is like a big farce when these ministers and deputy ministers just read out answers. It
Honorable
simply does not
Reddy.
make sense.
Honorable Reddy, order.
It's such a futile exercise.
Honorable Reddy, thank you. We've dealt with the matter. And the fact that you bring some honey to me doesn't mean you get another bite at the cherry. Honorable Cameron.
Thank you, Chair. Deputy Minister, you've given the number of murders reported, but the public, I think, deserves a bit more clarity on the outcomes. Of the murders recorded in 2024, what percentage resulted in a conviction-ready docket handed to the MPA and proceeded to prosecution? And if you cannot provide that percentage, would the minister or the deputy minister then concede that SAPS's detection rate measures paperwork, not justice? And I think the Honorable Mkalipi might have a point in that I found out that often the ANC gets
Honorable
briefed by the
Cameron.
Portfolio Committee the night
Honorable
before the-
Cameron, you also out
Thank
of
you,
order.
Chair.
Honorable Deputy Minister.
Thank you very much.
Order. Order. Let's give the Deputy Minister.
Thank you very much, Honorable Chair. The question from Honorable Ghana was the total number of murder cases that has been reported in 2024. And the figure that I've given was based on that question. So if Honorable Cameroon want me to have the percentage and the others, he can give me that question, then I'll be able to, because I have responded to what Honorable Ghana have asked. Thank you very much, Honorable Chair.
Thank you. The Honorable Abader.
Thank you, Chairperson. Honorable Deputy Minister, how do you stand before this House and speak of reported reported murders where thousands of families are still waiting for justice that never comes? What do you say to the mothers who sleep with their children's pictures because SAPS has turned murder dockets into dust collectors? At what point will this GNU government admit that its failures are not statistics, they are graves, and that your inability to solve murders in 2024 is turning South Africa into a sanctuary for criminals while victims are abandoned to pain and silence? Thank you.
Honorable Deputy Minister.
Thank you very much, Honorable House Chair. Honorable House Chair, as you are aware, last week, Friday, we released crime stats. And in terms of the crime stats that we read for the first and the second quarter, it has shown that the murder rate, the rape rate, and all other trio crimes and other crimes have gone down. And then it means that as the SAPS, we have put more effort and resources, but also concentrate on the hotspot as indicated by the top 30 and the top 50, so that we're able to bring the crime down. We are trying our best to also work with the Department of Justice in terms of the NPA SAPS project to ensure that the dockets that are ready to be enrolled in court are enrolled so that people can be able to get justice. But then it will depend how many cases are there and whether they can be enrolled or not. We are not ignoring cases that need to be put on the roll. It does not depend on us, but we are not also stopping in terms of what we want to do. And I can assure this House that we also have other measures that we are going to apply to be able to make sure that these figures goes even higher. Even if they are a little bit down, we are still worried they are high, and we're going to do our best to make sure that they become higher. As I'm talking to you, House Chair, we have launched what we call Safer Festive Period, where we are going to go all out in all the 9 provinces to make sure that we clamp on all people who are wanted, all people who have committed crime, and also illegal shebins and taverns where most of the rapes and the murders take place. So we are not going to rest and go on holiday. We are going to make sure that we keep our people safe and bring down the rate of crime. Thank you very much, House Chair.
Honourable members, question number 1271 has been asked by the Honourable Motaung to the Minister of Justice and Constitutional Development. The question is, given that earlier in the year, her department indicated that during the current financial year, it will focus on enhancing the anti-corruption framework in the Republic by implementing 3 bills, regulations, notices and proclamations. What progress has been made on the implementation process of the 3 bills to fight corruption to date? The Honourable Minister.
Thank you very much, Chairperson. My apologies, I had to leave. I've got a launch of a sexual offences court tomorrow in Free State. The department has developed draft bill proposing amendments to the SIU Act to, amongst others, revise provisions relating to establishment of the Special Tribunal, additional functions of the Special Investigating Unit, issuance of reports by the Special Investigating Unit, remedial action funding of the SIU, and nature of proceedings. The Special Tribunal, in the Special Tribunal, preservation, forfeiture of the proceeds of unlawful activities, appointment of curator bonus, and administrative sanctions. Secondly, we have been able to develop a bill that relates development of the bill relation into the protection of whistleblowers. This bill is called Protected Disclosure Bill that has been finalized and is currently in the process of consultation at the JCPS cluster level, able to introduce it into Parliament at the beginning of next year. We have also received inputs to the amendment of the NPA Act, which are being processed as well in terms of the JCPS. This one is still in the department where we are finalizing. Lastly, on the law reform, Commission is on the last stages to review the Criminal Procedure Act that will also be introduced to Parliament in the last quarter of this financial year. Again, NICEC report, as submitted to the President, has been studied by the department as required by the President, and technical consultation workshop has been held with all the law enforcement agencies to source their inputs on the recommendation. And in this regard, preliminary comments have been received and will be processed to the JCPS Ministerial Cluster. Thank you very much.
Thank you, Honorable Minister. The first supplementary question will be asked by Honorable Motaung.
Thank you, House Chair. I will take it on behalf of Honorable Motaung. The progress report is welcomed, Honorable Minister. Can you elaborate more to the House on how will the draft bill ensure that the SIU functions does not conflate those of other investigating agencies? In other words, to ensure a harmonious working relationship amongst all the agencies.
The Honorable Minister.
Thank you very much, Honorable Member. Indeed, one of the issues and what the President has committed was to ensure that we look at the overall work of the agencies, avoid duplication. And that's why in this regard, the NACEC report remains critical because it does deal with a framework in terms of law enforcement agencies that are fighting corruption and have been able to identify where the duplications are and made such a recommendation. So we will be able to come and present. For example, one of the proposals that they're making is that SIU becomes the anti-corruption agency in terms of all the South African population, so that we deal with it both in terms of corruption within the state and corruption outside the state. Thank you very much.
Thank you. The second supplementary question will be asked by Honorable Klopper.
Thank you, Chairperson. Minister, given the importance of a unified and decisive national response to corruption, has the department considered the Constitution 21st Amendment Bill 2024 not merely as a standalone proposal, but as a potential component to strengthen and consolidate the Republic's broader anti-corruption framework? If the bill, which proposes an independent anti-corruption commission with a constitutionally entrenched investigative and prosecutorial powers for serious corruption and high-level organized crime, as set out in Section 191A to C, has not been taken into account by the department's anti-corruption strategy, will the minister indicate the reasons for this?
The Honorable Minister.
Thank you. Thanks, Honorable Klope. As you know, when the bill was presented, the department did a full presentation in response, motivating why the proposals are not supported. This is not only because of the minister, but law enforcement agencies inputted into that and did disagree with that proposal. Thank you very much.
Thank you. The third supplementary question will be asked by Honorable Mohlala.
No, thanks so much. Minister, while you have outlined the drafting and consultation stages of SIU, Amendment Bill, the Protected Disclosure Bill, and the NPA Act amendments, you did not explain how your department is ensuring effective coordination across all law enforcement and oversight bodies to implement these measures. Can you clarify what concrete mechanisms are in place to guarantee that these bills, once passed, will lead to actual anti-corruption action and not remain on paper as mere legislation? Thank you so much.
The Honorable Minister.
Thank you, Honorable Mohlala. It's not the issue. Let me start first by saying there are certain things you can't do when the law does not give you powers to do it. So that's why the amendments are important, so that they can effect the changes that we want. The recommendation, for example, from the Zondo Commission, in terms of the commitments that the President has made. Secondly, in terms of the areas that we have identified, that's why we are introducing those legislation. In terms of the current mechanism, for example, SIU and an asset forfeiture unit in the NPA works collaboratively. For example, if you look at the Tembisa Hospital saga and how they've been able to take those assets, it was a joint effort between asset forfeiture unit in the NPA and SIU. So there are many examples that we can give in terms of collaboration, where you find that DPCI in the police would work together with NPA and SIU to be able to take other assets, preserve them, or even prosecute in terms of the work that needs to be done. So we're just saying in these bills, what we want to see is that there are gaps that we have identified. For example, strengthening the powers of SIU beyond just dealing with state issues, but deal with holistic corruption in society. Secondly, on NPA, it's particularly the issue of ensuring that NPA's financial and operations are independent, and therefore you can determine that the NDPP becomes the account, or the CEO there becomes the accounting officer of the NPA. And then again, when you look at the whistleblower, there isn't anything in the country currently that legislates the whistleblower protection. That's why there'll be different issues, and this has been a public outcry. So we know that once we enact that, it will protect whistleblowers. It will make sure that it's not only because they are witnesses to a case, but because they are providing information And some of the proposal, honorable member, if you can like to say, there are also people who are saying, let's look at incentivizing people. Let's look at how do we
Honorable
protect them.
Minister,
So that will be there.
your
Thank you very
time
much.
is expired. Thank you. The last supplementary question will be asked by Honorable Mngwango.
Honorable Minister, in light of the case of Mr. Bonkosi Shoisa, who was to be a key witness in the murder case of a senior municipal official from Wanongoma in KZN, and who was later found murdered inside a state witness protection safe house in 2018, how can the public have confidence in the implementation of the anti-corruption bills when witnesses essential to such prosecutions are not protected even within the very structures meant to safeguard them, and as such resulting in cases collapsing due to their deaths?
The Honorable Minister.
Thank you, Honorable Mngwango. While it's a new question, but let me deal with it. After the incidences where we had challenges in terms of witness protection houses, and also the mechanisms of witness protection. That's why now you have witness protection across the country in terms of region. The minister does not get to see, to know who are the people that are actually in the witness, and NPA, because it's linked to cases, they are responsible for this. And we are currently, as I say, finalizing the whistleblower protection bill that will assist in protecting those who have information and all that. Currently, we have made sure that we strengthen the witness protection. That's why you'd see people are able to testify, for example, in many courts, they are able to testify even in commission, and it's provided for them even offline. So the mechanisms previously that would have made witnesses weak, vulnerable, have been implemented, Honorable Mngwango. That's why you can quote a case of 2018, because there isn't a recent case of a witness that has been killed in protection.
Thank you, Honorable Minister. Honorable members, we now move to question number 1281, which has been asked by Honorable A. Seros to the Minister of Home Affairs. The question is whether his department has identified the next phases required to fully operationalize the stages visa system aimed at streamlining applications for international film and creative professionals. If not, why not? If so, what are the timelines and key milestones for implementation? Whether his department has quantified the expected economic benefits in terms of investment attraction, job creation, and skills transfer resulting from the specified visa initiative. If not, what is the position in this regard? If so, what are the relevant details? The Honorable Minister.
Thank you, Honorable Chair. Just to indicate that STAGES is the acronym for Screen Talent and Global Entertainment Scheme. It's a new online visa platform for the creative sector and the film industry and other productions like this. It was published and activated in the Government Gazette on the 10th of November 2025. Federations, organizations, and associations involved in facilitating film production that meet the selection criteria published in the Gazette and are interested in being considered for admission to STAGES have been invited to submit an expression of interest and supporting documents using the STAGES link that is available from the department's website. In terms of the next phase to fully operationalize this scheme, it involves evaluating, assessing, and validating the submissions. This will be done like it was done for the Trusted Tour Operator scheme by an interdepartmental committee comprising technical officials from the Department of Home Affairs, the Department of Trade, Industry and Competition, the Department of Arts and Culture, and any other relevant department. The STAGES Interdepartmental Committee will, after assessing and validating the applications, make recommendations to myself on the admission to the program. Applicants will be advised on the outcome of their applications within 30 working days from the 10th of November. those federations, organizations, and associations that are successfully admitted to stages will be granted access to the dedicated visa application platform in digital form, which really will be able to ensure that we provide visa outcomes for this creative economic sector within 24 hours. According to the National Film and Video Foundation's 2020-2021 Economic Impact Report, the total impact of the film industry on South African GDP is currently estimated to be about 1.08 billion rand. The report, however, further suggests that for every 1 rand of additional expenditure that comes from international film productions facilitated through something like stages, an additional 2.82 rand of income is generated in the economy. In terms of employment, the report estimates that for every 1 million rand that stages generates in direct expenditure by production companies in South Africa, an average of 5.65 additional new jobs can be created annually. Thank you, Chair.
Thank you. The first supplementary question will be asked by Honorable Roos.
Thank you, House Chair. The formal establishment of the Stages visa scheme is a major milestone for South Africa's creative economy. It reflects a growing policy focus on using immigration as a driver of economic growth and international collaboration. Minister, what mechanisms will you put in place to guarantee predictable turnaround times, consistent processing across missions, and real-time monitoring so that delays are detected before they derail international productions?
The Honorable Minister.
Thank you, Chair, and to the Honorable Roos. Firstly is that we are not doing anything new. We've already demonstrated with the Trusted Tour Operator scheme that this approach of digitalizing the visa process is able to deliver outcomes within very quick timeframes. As I said, I think we are averaging 24-hour turnaround times currently. So it is the same mechanism that will now be extended for the creative economy, as you've mentioned. But of course, the linchpin of all of this is that we are eradicating the paper-based and manual processes that previously led to massive delays, in addition to issues of fraud and corruption. Because there was one case that I've cited before where Netflix actually ended up moving a 400 million rand production to Mexico, even though they wanted to bring it to South Africa, because of the delays that were involved in the visa process. So it is a tried and tested model now. It is really another benefit of the focus on digital transformation that we have adopted as our apex priority. And I'm confident that we will see similar results as we've seen with the Trusted Tour Operator scheme. I know the industry is very excited. We've received some very positive feedback in terms of what this scheme can do to really take South Africa to the next level. We have everything we need to be a world-class and sought-after destination to create jobs in our production and creative industries. And I think Stages really adds to the attraction of South Africa as that kind of destination. Thank you.
Thank you. The second supplementary question will be asked by Honorable Ngubane.
Thank you very much, Honorable Chair. Minister, the report you are giving us is, the report and feedback is false. Do you know, the Minister, that this so-called Visa International Film for Creative Professionals is contributing to the abuse and exploitation of South African creative industry, since these international films never create any employment opportunities for local artists, but are abusing them and even ignoring them or pay them what is called stipend, while they pay themselves exorbitant salaries. The senior actors in South Africa become juniorized since they rate themselves higher than the South African actors. Now that you know that the so-called film tourism investment is led by exploitation, what is the minister going to do about it? Most of the so-called employment creation visa granting is being abused by foreign internationals. The other examples on the lowest level of this are Uber Eats, Pick and Pay 60, Uber drivers in South Africa. Most of all of them employs 90% of illegal immigrants. So, Minister, what are you going to do with this system of yours that is exploiting the labor market in South Africa?
Time has expired.
Thank you, Chair.
The Honorable Minister.
Thank you, Chair. That's quite a strange suggestion because Stages has not been implemented yet. So I'm not quite sure how on earth it could be doing all these horrible things that the honorable member is speaking of.
Honorable Minister, your
It is
network is
currently
bad.
in
Can you
the
move to the
phase
other side?
of requesting expressions of interest from local and see if that assists. Can you hear me now?
Yes, we can hear you. Continue.
Thank you. So as I mentioned, Chair, we are still in the expressions of interest phase for those companies to come forward and indicate whether they want to use this system. But I think I would really encourage the honourable member to go and Google that National Film and Video Foundation's report for economic impact of the South African film industry. All the research and the numbers are there. And I think in a country like ours, the real labour exploitation is a high unemployment rate, an unemployment rate of over 30%. That is exploitation. And that is what we should all focus on. It is the apex priority of the GNU to generate economic growth and reduce unemployment. And I am quite encouraged that South Africa's booming creative sector is going to get another boost on the international stage by making sure that we attract these big productions to South Africa. Thank you.
Thank you, Honorable Minister. The third supplementary question will be asked by Honorable Mohale.
It's me, Mohale. Thanks, Chairperson.
Okay, I didn't know that Mkhalipi is now Mohale. Continue, Honorable Member.
Thanks, House Chair. In terms of predictable timelines, given historic delays in specialized visa categories, what specific operational changes beyond digitization are being applied to ensure that stages applications are processed within the timelines? Thanks.
The Honorable Minister.
Thank you, Chair, and to the Honourable Mkhalipi. The first important point to make is that there's a dedicated team that works initially on the Trusted Tour Operator Scheme, but now also on the Stages Initiative. So it has dedicated capacity really around the clock. It is also something that is monitored on a continuous basis to ensure that we do meet those standards. And I think the feedback certainly from those tour operators who have participated in TTOS, which works on the same principle as stages, will give the House comfort that these turnaround times are indeed going to be met. But I think the honourable member raises an important question because it actually extends beyond this particular scheme. Of course, we want to meet turnaround times across the board. And again, the mechanisms to get there is really to automate as much of the process as possible. And I think that is ultimately where all of these kind of initiatives lead us towards the ETA, which is a fully automated system that operates very much like the South African Revenue Service's tax filing system to remove those kind of delays and manual processes. So that's the direction we're going overall, and I think Stages takes us closer to that once again. Thank you, Chair.
Thank you. The last supplementary question will be asked by Honorable Ghana.
Okay, so I'm much told. Minister, so this is a very worthy intervention. I wanted to check if there's a similar intervention that you would introduce, especially for in the professional football space, given the number of international players that the professional teams sign, but also the naturalization of players that have been plying their trade in South Africa for more than 5 years, that at times takes more than 6 months to be finalized and processed. So just to check if you would extend this kind of a regime to other industries like football.
The Honorable Minister.
Thank you, Chair. I am sorry that my video isn't working because then the Honourable Ghana would have seen the smile on my face. He's asking exactly the right question. The answer is yes. There is a very similar scheme that we are developing for international artists and sports people to also facilitate South Africa's standing as a global destination for those type of events. So absolutely, this approach I think has been proven to be a success. We started with tour operators. We are now moving to the creative industries. And indeed, then sports and arts and culture will become one of the next spaces that we will like to extend this to. In terms of naturalization, that is, of course, an established process that is provided for in law. So that will not really be affected by this, but certainly our ability to attract international artists, sporting coaches, sports people will all receive a big boost once we roll out that as the next phase of really our contribution to making sure that we pursue that goal of growing our economy in every way that we possibly can, and really positioning Home Affairs through technology as that kind of economic enabler. So thank you to the Honourable Ghana for the question. And this is one of those that could have ended with a simple word, yes. And I think that's quite encouraging. Thank you.
Thank you, Honorable Minister. Honorable members, we move to question number 1317, which has been asked by Honorable MP Mohammed to the Minister of Home Affairs. The question is, since the launch of the Border Management and Immigration Anti-Corruption Forum, what are the reasons that has not taken action to clamp down on syndicates and officials who exploit the visa and immigration system? How will digitizing entry and exit points across the Republic help clear the visa backlog and thereby improve the processing times for foreign workers and migrants? The Honorable Minister.
Thank you, Chair. So there are two aspects to this question. The first one dealing with the Anti-Corruption Forum. Just to indicate that in that regard, the question is quite contradictory, because the establishment of the Border Management and Immigration Anti-Corruption Forum is itself an expression of the clampdown on long-standing corruption within the sector. The forum was not established as a single once-off event, but as a permanent strategic platform to deal with this problem. Its primary objective is to foster a collaborative multi-agency approach to identify, prevent, and combat corruption within the border management and immigration environment. Honourable members may recall that prior to its launch, efforts by individual departments such as Home Affairs, the Special Investigating Unit, the South African Police Service, the State Security Agency, and the National Prosecuting Authority, as well as the BMA, were often siloed. The forum now breaks down those silos to ensure a unified and intelligence-driven national response to the sophisticated syndicates that operate within the space. When this forum was launched earlier this year, I warned that South Africa, in the wake of state capture, is increasingly a syndicate society. It's one of the consequences of the state capture we saw under the leadership of the leader of the party, of the member who posed this question. And we are now dealing with it in a very systematic way. It is in recognition of this fact that we have to fight these entrenched syndicates and the pursuit of corrupt officials, that it requires complex and meticulous evidence-based work, that this ecosystem has really taken the lead in using the forum to drive disciplinary action and prosecutions. Chair, briefly in terms of statistics, 25 officials have been dismissed from the BMA since I assumed office. 11 more have been arrested, and there are a number of additional cases underway. Dismissals at Home Affairs are now over 30 in the individual cases. So clearly the fruits are there for all to see. Chair, the second part of the question, the ongoing project to upgrade the movement control system that I mentioned earlier includes its integration with the electronic travel authorization. The ETA is designed to replace the manual visa process with a fully digital end-to-end solution that automates the immigration processing lifecycle. Once a traveler's authorization is completed electronically and their facial biometric is linked to the upgraded EMCS 2.0 that I mentioned, port officials will be able to verify the traveler's details instantly through facial recognition and finalizing processing more efficiently. This will all contribute to clearing the delays that the question raises. Thank you, Chair.
Thank you, Honorable Minister. The first supplementary question will be asked by Honorable MP Mohammed.
Minister, I don't know if you heard of the phrase, people in glass houses should not throw stones. But anyway, thanks for your response. Can you please explain why no high-level arrests or dismissals have followed the many whistleblowers' report on visa fraud? What consequent management has actually taken place since the forum's launch, and can you give the House one single example of a syndicate disrupted under your watch? And has the department conducted any audit to determine how many officials are involved in permit and visa bribery schemes? And if so, why are those findings still not public? Thank you.
Thank you very much. The Honorable Minister.
Thank you, Chair. I would suggest that someone who is in a party led by Jacob Zuma they live in a glass house and they should be very careful to throw stones. So I think the honourable member must heed her own advice. Chair, I mentioned some of the numbers, but let me indicate them again.
Honorable members, please, can we listen to the response? Honorable members, can we please listen to the response? Honorable Minister.
Thank you, Chair. Just to reiterate some of the concrete statistics that the member is asking for. Since the launch of, or since the start of this administration, 25 officials have been dismissed from the BMA. 11 have been arrested for acts of misconduct relating to corruption. There are a number of additional cases underway, and that is not even including over 30 officials that have been fired from Home Affairs, as well as, I think, 8 different prosecutions that have been secured in the Home Affairs environment as well, some of them relating indeed to the immigration space. So, Chair, I think the premise is simply flawed. We have never seen the speed and urgency at which these cases are being finalized as we are currently seeing being done across BMA and the Department of Home Affairs. And indeed, the work of Dr. Lubisi's multidisciplinary task team, the work of the Special Investigating Unit. These are all things that have been consolidated into this forum and this coordinated strategy, and that is yielding the fruits that we are now seeing. Thank you.
Thank you very much. The second supplementary question will be asked by Honorable Roos.
Thank you, House Chair. House Chair, this is another whopper from the MK. I find it incredible, baffling to suggest that the minister has not taken action to clamp down on corruption. We've heard in our own committee meetings, where Honorable Mohammed was present, that 54 officials from Home Affairs and the BMA have been dismissed for corruption or misconduct. 8 individuals have been convicted and sentenced to prison, terms ranging from 4 years to 18 years imprisonment. Prosecutions against another 19 officials are underway. Minister, my question is, how will the digitization of entry and exit points assist with tackling illegal immigration? Thank you.
The Honorable Minister.
Thank you, Chair. I think our approach to dealing with these syndicates and with corruption is twofold, and it's really worth emphasizing again. On the one hand, there's accountability and all of the things that we have just been discussing around arrests and people being dismissed, and the work of the SIU in collaboration with this forum. So that is one key part of the equation. But the other key part of the equation is to close the loopholes that these corrupt individuals and syndicates exploit. And that is where the honourable member's question is relevant, because once we remove that discretion from officials, once we close down the space for people to manipulate pieces of paper or manipulate and delay processes so that they can solicit a bribe or something of the like, that is the moment when we are systematically closing the loopholes for corruption. So I've said it before, you cannot bribe a computer. Once you arrive at a border post or in any other context to apply for a smart ID or whatever the case may be, once that process is fully automated and there is no longer any space for you to manipulate or distort that particular process, that is the day in which we will have truly won the fight. So accountability is a critical part of our approach, but just as important are those systematic changes to know once someone has been fired or convicted for one of these offenses, that you're also then closing the door behind them to make sure that no one else can use that same loophole in future to commit these kind of offenses against our country. Thank you.
Thank you. The third supplementary question will be asked by Honorable Mohale, which is Honorable Mukalipi.
Thank you very much, Chair. Minister, what budget has been allocated to anti-corruption operations within the Border Management Authority? And is it sufficient to dismantle organized syndicates? Can the minister confirm whether the digitization project will include biometric integration and how this will prevent repeat fraudulent visa applications?
The Honorable Minister.
Thank you, Honourable Chair. I don't have the budget figure with me, but I can tell you honestly that it won't be sufficient to fully dismantle and enforce accountability because of the earlier reference I made to the BMA's chronic underfunding. But we are grateful to see that in the medium-term budget policy statement that was delivered by the Finance Minister recently, that there is some additional money in the pipeline for BMA. And I think that will begin to assist us with exactly capacitating these kind of functions. Secondly, Chair, on the integration of biometrics, yes, absolutely. And I think the question specifically referred to duplications or fraudulent applications, etc. There is very powerful technology that we are really leading the world on, that we are developing and pushing, that will enable us to do verifications using facial recognition, where we are now not only checking someone's face against their own record in our database, but where we're able to check that face against every record in our database and do that instantly. And you can imagine our ability to, to detect duplicates or records that have been manipulated through technology like that is very powerful indeed. That is something that is already being utilized in the ETA process, as well as our new citizenship confirmation portal. And that is going to be expanded into the digital ID space as we move forward. So indeed, a very powerful tool to pick up on those kind of duplications and manipulations within the system. Thank you, Chair.
Thank you. The last supplementary question will be asked by Honorable Makri.
Thank you very much, House Chairperson. Honorable Minister, given the persistent reports of officials facilitating fraudulent permits, despite the establishment of the Anti-Corruption Forum, what specific investigative or disciplinary measures have you initiated to ensure accountability with border and immigration services? If not, why not? If so, what are the relevant details? Thank you.
The Honorable Minister.
Thank you, Chair. If you'll allow me, I wouldn't like to repeat those numbers a third time. I think the question has been adequately answered in terms of the accountability measures that are being implemented. And of course, if the Honourable Member has any specific cases that she's referring to, then she's most welcome to bring those forward. But I would submit that that question has been answered. Thank you.
Thank you, Honorable Minister. Honorable members, the 3 hours allocated for questions today has expired. Outstanding replies received will be printed in Hansard. We will now take the questions standing over in terms of Rule 1441, and as previously indicated, an additional 30 minutes will be added to today's question time for these papers. I now take question number 1040, which has been asked by the Honorable M.A. Maimane to the Minister of Basic Education. The question is about the total number of learners that are expected to write the 2025 National Senior Certificate Examinations and how many from the original grade 1 cohort will not be writing the specified examination. The Honorable Minister.
Thank you very much, House Chairperson. The Department of Basic Education has advised that 766,543 full-time candidates had been registered to write, 137,018 part-time candidates were registered to write. This represents 903,561 candidates across all provinces. I'm also advised that based on the original grade 1 cohort, 1,235,901 learners and 466,900 learners from that cohort will not be writing the full-time NSC in 2025. Honorable members, these numbers must be interpreted carefully to avoid a common misunderstanding. The assumption that all learners who are not in the NSC full-time cohort have dropped out is factually incorrect. Many learners move into other legitimate pathways in the education system. Learners transition to TVET colleges or technical or occupational schools of skill, community colleges, or pursue NSC through part-time registration. Others move to independent schools that write the IEB or Sakai exams. And these learners remain within the broader education system, even if they are not counted in the public school full-time NSC figures. It's also important to note that some learners progress through the schooling system at different speeds due to grade repetition, subject changes, and personal circumstances. These patterns are not exceptional, they are typical in any schooling system. Chairperson, the department continues to strengthen its learner tracking tools to make sure that we understand where all learners are going. But more importantly, we are tackling the long-term factors that influence progression, retention, and successful completion. These include making sure that we strengthen the foundation of learning, improving attendance and participation, ensuring access to the school nutrition program, reducing financial and social barriers to no-fee schools, ensuring that pregnancy does not result in permanent school exit, improving access to textbooks, professionalizing the ECD, and improving grade R readiness, expanding mother tongue-based bilingual education, and reviewing the post-provision norms to strengthen foundations of teaching. Chair, our focus is to ensure that every learner, regardless of the pathway they choose, remains within the education system and emerges with a meaningful qualification or skill. Thank you.
Thank you. The first supplementary question will be asked by Honorable M.A. Maimane.
Thank you very much, Chair. I will take, and I'll do the supplementary questions. Minister, given the number of learners who sat for the 2025 examination cycle, and given the numbers that you've just shared now, what lessons has the department drawn from the exam cycle regarding the system readiness, regarding just the learners that ultimately did sit, and what are the ways and what will inform improvements for the 2026 academic year, but also more broadly, what will inform improvements to the education system itself, particularly now for high school learners that are preparing for the next coming years of the matric examinations?
The Honorable Minister.
Thank you very much. And the honorable member is quite right. And I think it's a very valuable question because it's very important, as I indicated, that we don't just look at numbers in the very narrow sense of it. So she's asking the question about what lesson have we drawn from this cohort? Number one of the key things that I think has been learned is that in order to keep learners in school for longer and retain them in schools and avoid grade repetitions to the point where some children are too old to be even in a particular class, we have to make sure that we are strengthening the system from the ground up. We have to make sure that not only things, for instance, such as school safety, school nutrition, these are all things that contribute to children being able to progress. But also, one of the things that we need to do, and we need to make sure that particularly for high school children, that we are supporting them particularly in the uptake for maths and science, because we do believe that the drop in the participation for maths and science is a cause for concern. And so while, of course, we're wanting to strengthen the foundations of learning, because regardless of whatever you do in the higher phases, if you don't focus on the foundations, you're not dealing with the cause. But ultimately, those learners now who are in the system must be supported. Provinces have what we call the Maths and Science and Technology Grant. All of those things are designed to make sure that we're not only making learners pass, but they're passing with quality and with a quality skill so that they can either go to university, to technical colleges, but not just simply passing for the sake of it. So I think the key lessons have been, you've got to strengthen the system from the ground up, but at the same time, you can't allow learners who are already in the system without supporting them effectively. Thanks.
Thank you. The second supplementary question will be asked by Honorable Makakula.
Yes, Honorable Magagula, what progress has been made in integrating the learner tracking system with other departments such as higher education, labor, and home affairs in order to obtain a more comprehensive understanding of where the learners transition to? Thank you.
The Honorable Minister.
Another excellent question, House Chair. In fact, when we announced the matric results at the beginning of the year, one of the things that I undertook to the nation was to say it's very, very important that we as an education system, we don't simply say, as the honorable member, Honorable Maimane asked, we don't just simply say, this is how many learners have started, and this is those learners that have exited. That we need to have accurate data of the learner that started in grade 1 or in grade R in 2025 or 2026, what specifically happens to that learner by the time they get to grade 12? If they leave the system because they're going to a TVET, that's fine, but we need to account for that. We need to be able to come to you and account and say, we know for a fact that a third of the learners that are no longer writing the NSC exams have gone to TVET colleges. We know some of them have gone to technical schools. We know some of them have gone to to write the IAB. So the honorable member asked, what are we doing? Minister Manamela and I are working very closely to make sure that both our departments align with their numbers, because one of the unintended consequences of having two separate departments is that the way in which we collect data and the way they were collecting data, we're not speaking to each other. So we've since established a team, a technical team from both our departments to make sure that there's seamless transition of learners in the education system, because ultimately, Chair, this is one education system. It's not higher education or basic DBE. So it's important that we know where our learners are, so that when Honorable Webster asks me, where did these learners go if they're not writing matric, we need to be able to accurately reflect exactly where they've gone to. So that's an undertaking we've made, and I'm pleased to say there's progress in that having been made with that, Honorable Member Low, and that in the announcement of the matric results this next year, we will be able to account fully.
Thank you. The third supplementary question will be asked by Honorable Shikwamban.
Kwambane today.
You are many people today.
No, Minister, since the question is in relations to international relations, where you compare this question. So, awusixelele ntombi, 30% loan phasisa ngasengane, nufundephi? Which country is also applying the same 30% mark that we are also doing in South Africa?
The Honorable Minister.
Thank you very much, Honorable Member. And I'm glad the Honorable Member has asked this question because it's an important one. The reason why it's an important one, Honorable Chair, is because there is a tendency, one, to make this a populist debate. I welcome the scrutiny by this House to ask the question, are there assessment requirements for children at an internationally comparable state? We welcome the scrutiny by this House, but to make it a populist decision and to make it a populist debate is wrong. Because there's nobody. Well, allow me to finish. Allow me to finish. No.
Honorable members, can we please allow the minister to finish?
No, Chair, please protect us as well. You can't be viewed as people who are populist. This is very serious. 30% mark. Where
Honorable
get from other
Mkalipi.
countries, please.
Honorable
There's nothing
Mkalipi.
populist about it. It's a serious
Honorable
matter.
Mkalipi.
Or you don't want our
Honorable
to speak like you.
Mkalipi.
You don't want us
Honorable
to speak like
Mkalipi.
you.
That is unnecessary.
I am protecting you by saying, can we allow
Unnecessary.
honorable members?
No, you don't.
Honorable members.
Talk about me and how I speak like that.
Honorable members, Honorable Minister, please do not engage in that. I want to give you an opportunity to respond to the question. There is absolutely no need to respond to Honorable Mkalipi. Please. I am protecting you by saying, can we allow the minister to finish and see if she does really answer the question? Please. Honorable Minister.
Honorable Chair, thank you very much. You're right, I shouldn't engage. Chairperson, it is incorrect to claim that there are children in South Africa who pass with 30%. That's why I'm saying to you that this is a populist way of dealing with the results. We have repeatedly explained that out of the 800,000 learners who wrote the NSC exams, those who met the basic requirement are less than 200. To then claim that you need only 30% in South Africa to pass the NSC exams is a false equivalence. And we have said, simply saying you're raising the bar and you're saying we're going to increase to 50% when you're not dealing with the root causes, when 8 out of 10 children in this country cannot read for meaning, you are not fixing the root causes. If you are serious about improving education, which I really want this House to be, if you are serious about improving education, then you are going to support our efforts to make sure that the foundations of learning are strong, that the foundations at the beginning are strong. And ultimately,
Honorable members, Honorable Minister, can you please pause? Honorable members, Honorable members, Honorable members, order. Honorable members, Honorable members, especially from my left. Honorable members, Honorable Mkalipi. No, please. No. You are conversing and I'm addressing the House. Please, the minister is not yet finished with responding. And the way you are howling, other members cannot even hear what the minister is saying. I here seated, I cannot hear what the minister is saying. Can we we ask questions because we want responses. But now if we are not going to afford ministers to respond, then we're not fitting the purpose of the question and answer session to ministers. Can we please allow the minister to finish? Please, continue, Honorable Minister.
Additionally, Chair, I want to assure this House, as I have indicated before, that I have appointed a body of experts that is going to look at the criteria of assessments, not only just in grade 12, because that's not how you fix an education system, all the way from grade R all the way to grade 12, where are they going to examine whether or not our assessment criteria is globally comparable. But what we cannot do is reduce this debate that it must be politicians who must be determining what needs to happen. We have to be evidence-based and led in our response to the crisis of our education system. Allow the experts.
Thank you,
to lead us
Honorable
in this
Minister.
process.
Your
Thank you.
time has expired. Honorable members.
Chair, please note my hand. Chair, please note my hand.
Honorable Pastor, you could have simply raised your hand. I would have noted. There's absolutely no need to open the mic. You want me to note you or you are raising a point of order? Okay, what is your point of order?
I had raised my hand, Chair, for a long time. The point of order is on Rule 142 about relevance of answer. I think it's an important question on global reference that has informed the 30%, and I would like the minister to answer that.
I think the minister did reference to the international, unless, let me just afford 30 seconds maybe to do that.
So
No, honorable members, I can't be using my discretion in affording the minister and yet you are howling again.
You too.
I will just tell the minister to sit down and then we continue. Honorable Minister.
Honorable House Chair, as I indicated, the experts who are looking at this work will look at whether or not our assessments are globally comparable, whether or not children are leaving school with the requisite assessments. And I think the House will be pleased to know that once this work is done, we will make it public. We will come and table it here in this House, and we remain open.
Thank you very much, Honorable Minister. The last supplementary question will be asked by Honorable Thring. Honorable Thring.
Chair, there's no supplementary question from my part on this question. Thank you.
Thank you very much. Honorable members, we're moving to question number 1010, which has been asked by Honorable P.P. Kabanchaba to the Minister of Basic Education. The question is about what measures has the department taken to ensure that age-appropriate, developmentally sensitive sexuality education is integrated into early childhood development programs to equip children with knowledge about bodily autonomy and personal safety as a key strategy to empowering children against sexual abuse. The Honorable Minister.
Thank you, House Chair, and thank you to the Honorable Member. Our starting point, I think, is quite clear, Chairperson, that children must be safe, they must be informed, they must be empowered from the early years of development. Age-appropriate, developmentally sensitive sexuality education plays an essential role in protecting young children, particularly from abuse and exploitation and harm. The department uses UNESCO's International Technical Guidelines on Sexuality Education, which begin at age 5. Since children in ECD centers are often younger than this age, what the department does is that it works with organizations such as the Teddy Bear Foundation Ilifa Labantwana and others to equip ECD practitioners with the appropriate tools to teach body autonomy, recognizing unsafe behavior, and how to seek help. So we are equipping the practitioners to be able to pick up whether or not children are being abused or sexually harassed or abused at home. This is not adult content. The content that children will consume after age 5 is not adult content. It's about protection, it's about safety, and it's about early identification of abuse. It's an essential part of a whole of government approach in combating the rising levels of violence against children. If I may emphasize this, sexual abuse cannot be excused anywhere, not in schools, not in homes, and not in communities. The harm that children experience does not begin and end in a classroom. It often extends to what happens in the community at large. And so that's why the Department of Basic Education is working with other departments to make sure that we do this work. We are strengthening our training for ECD practitioners, improving support for centers dealing with abuse disclosures, and ensuring referral pathways to social development, health, and the South African Police Service to make sure that we are responsive. Our responsibility is quite simple, keeping young children safe, informed, protected, however, without exposing them to information that is not age appropriate. Thank you.
Thank you. The first supplementary question will be asked by Honorable Kabanchaba. Honorable members, you change your last
kana-
names every day. Are you Honorable Kabanchaba?
I'm joking. Thank you, House Chair. How has the department established a support framework to empower parents and guardians to actively promote children's safety and bodily autonomy?
Honorable Minister.
Ndiyabulela Honorable Law. Lento bendiyitsho into yobana especially abantwana abangaphansi kwe-age ka-5. Into efuneke siyenzile, funeke si-empowerishe i-ECD practitioners zizokwazi into yoba zidetecte xa umntana khe ibe ngathi uyahlukunyezwa. Ultimately, we cannot combat indaba ye-sexual violence nokudlwengulwa kwabantwana on our own. We have to form partnerships nabazali. Abazali funeke bayazi into yobana xa i-ECD practitioner has raised an issue with them, xa eba-advise into yobana siyiripota phi le nto, siyiripota ku-social development, siyiripota kwa-health, siyiripota nakwa-SAPS, so that we can make sure that we have successful prosecutions. One of the greatest tragedies, Chair and Honorable Law, is that in our sector, while we have SOPs to report sexual violence, the actual prosecutions, successful prosecutions, are very rare because sidilishana nabantwana, sidilishana nee-families sometimes ezingafuni ukuza kube emapoliseni and give ubufakazi obufanelekileyo. So asizukwazi uyilwa le nto singaba-involvanga abazali. Abazali are critical in the combating of abuse against children.
Thank you. The second supplementary question will be asked by Honorable Shikwamban.
Ushikwambana Chair.
Continue.
Abazali bayingxenye vele yesikolo, SGB parenting. So if you are saying that you are going to involve parents, in what way? Because they are already there. So please just tell us what are the plans of the department to deal with this scourge of raping kids in school? Because you can't be telling us parents are already stakeholders in many ways.
Honorable Minister.
Thank you very much, Honorable Member. The question, remember, it referred to ECDs. So what it referred to was 0 to 5-year-olds. But what I did was generously explained what we do beyond those who are 5 years old. So let me explain again, and I think it bears explaining because the Honorable Member's question is a very important one. We've been dealing with the scourge of sexual violence in our schools in an unprecedented way. In fact, I am pleased today, Honorable Member, that you've given opportunity for me to actually inform this House that as of today, we have cleared all 60 sexual predators who were found on the sexual offenders register as a department. And while yes, this is a commendable way of moving forward, it's still not enough. We still need to make sure that in our schools, children are safe. In our schools, teachers are not the very same predators. So on the one end, we are making sure that we're working with justice to make sure that the sexual offenders register is updated so we can consistently check against it. But when we're dealing with ECDs, and you're right, SGBs are an integral part of a school community. But with ECDs, because there are no school governing bodies, what we are saying is that inqalenyana yo practitioner nomzali has to be much closer. on a one-on-one basis. Ukwenzela uba if the practitioner is the one that identifies uba umntana mhlawumbe udlwengulilwe, akwazi uthetha nomzali, and siyaba empowerisha ke ngoku practitioners to know where do they go when they find this kind of abuse. But when we're talking about schools in general, I could not agree with you more. It is a crisis, and it's a crisis that I really hope that this House can help us fight as all as leaders, because this is a societal issue. But as I said, I'm pleased to inform you today that those we found on the register who were still teachers have today been fired by operation of law.
Thank you. The third supplementary question will be asked by Honorable Boshoff.
Thank you. Chair, I would like to ask the Minister, during the previous administration, there were documents which were quite, what shall I say, disconcerting about the age appropriateness of the material which was prepared at that stage. And then there was also a list of international institutions, whatever you want to call it, who were involved in drafting this and even provided the money for the studies. I would like to know who are the partners, or are they external partners, or who are the people working and drafting these documents? Thank you, Minister and Chair.
The Honorable Minister.
Thank you very much, Honorable Member. As I indicated, we are working with the UNESCO International Technical Guidelines on Sexuality Education. And I think you raise an important point, because sometimes there's a misunderstanding when you are teaching children about this kind of work. People often think that it's ideological work, or you are teaching children about sexuality, and that's not what is happening. What you are doing is you are teaching children about bodily autonomy. You are teaching children about how to identify when they have been sexually abused, how to report, and all of those things are pretty critical in terms of how do we make sure that children are protected from sexual violence. It does not in any way overstep and talk about sexuality and other things. So this in particular that I'm talking about is guided by UNESCO, and it's an internationally acclaimed way of teaching children about their safety. As I indicated, our primary goal here is to make sure that children are safe. And if they do experience sexual violence, they know what's appropriate, what's not appropriate, how adults should be teaching them, and how adults should not be treating them. So then it allows us then to have early detection of abuse. And if a child is abused, then we can take this up with the South African Police Service. But it really does just deal with the issue of safety of children and less about sexuality education.
Thank you. The last supplementary question will be asked by Honorable Ismail Musa.
Malibongwe, Honorable Minister, would your department consider digitalizing the program and put it in the hands of parents in the privacy and comfort of their home, providing data and positioning the new program as part of the UNICEF Strengthening Parenting Program, which is already digitalizing? Religious spaces such as churches and mosques and places of worship, etc., will only be too happy to offer or grant safe spaces as well. Educators should not be assigned to give sex education to learners. This should be undertaken by the parents and relevant caregivers. Thank you, Minister.
The Honorable Minister.
Thank you very much, Honorable Member. I must say that's an excellent idea of being able to provide material to parents to be able to do this kind of work, because as I was saying to Honorable Mkalipi, parents are critical to this kind of fight. If we are making them partners, particularly at ECD level, then they can have these conversations with their children, not only in the comfort of their own home, but also in a language that they are comfortable with, in a manner in which that they are comfortable with. So this is important. I think it's an excellent idea, one that I intend to take forward. But we also must make sure that it's not just about digitalization, because if you look at particularly in places like rural areas, for instance, parents may not be able to access these things online. So I think what your idea is an inspired one, that we should be able to offer a wide range of resources for parents as well, not just the practitioners, so that we can make the parent a far closer ally in fighting sexual abuse in our schools. So thank you very much for the idea. I think it's an excellent one.
Thank you, honorable members. That brings us to the end of the allocated time for the 30 minutes that were outstanding on the questions. I will now allow the secretary to read the first order.
Consideration of Public Service Amendment Bill and of report of Portfolio Committee on Public Service and Administration thereon.
I will now recognize Honorable J.N. de Villiers.
Thank you, Chair. Today marks an important step towards fixing the engine of the state. The Public Service Amendment Bill is not merely a technical adjustment to legislation. It is a structural reform that goes to the heart of how this country is governed. As the Portfolio Committee on Public Service and Administration, we welcome this bill because it restores clarity, accountability, and professionalism to the public service. For far too long, the line between politics and administration has been blurred. This has weakened institutions, created uncertainty for managers, and ultimately harmed service delivery to millions of South Africans who depend on efficiency and an impartial state. Our public administration cannot succeed when senior managers lack the authority to manage their departments, when accountability is diffused, or when political pressures interfere with the day-to-day operations. This bill provides the public service reform we urgently need. One of the most important provisions is Clause 4, which establishes mandatory delegation of authority to heads of department. HODs will now have clear and undisputed authority over recruitment, appointments, transfers, performance management, and other administrative powers. This removes the ambiguity that allowed politicians to interfere in operational decisions and empowers professionals to manage departments effectively. It also means the HODs can finally be held fully accountable for the results that they must deliver. Closely linked to this is Clause 16, which limits the political rights of HODs and their direct reports. Senior administrators will no longer be allowed to hold political office or engage in political campaigning. This ensures that those entrusted with managing the machinery of the state are focused on running departments, not running for office. It protects both the integrity of the civil service and the stability required for long-term planning. Politicians set the direction. Public service professionals must deliver the results. These changes bring South Africa in line with countries that have successfully separated politics from administration. Botswana's merit-based bureaucracy remains one of the strongest on the continent. Singapore's professional public service enables decades of rapid development. South Korea, Rwanda, and the United Kingdom all used similar reforms to modernize their states, improve service delivery, and rebuild public trust. The lesson is clear. Where administrators are empowered to manage and are shielded from political pressures, institutions become stronger, more stable, and more effective. The urgency of reform cannot be overstated. Our committee has repeatedly seen how overlapping political and administrative authority fuels inefficiency. Ministers currently have the space to meddle in administrative decisions. Managers lack the authority to discipline, recruit, or restructure. Essential services break down because accountability is blurred and leadership is fragmented. Citizens pay the price through failing hospitals, collapsing infrastructure, and the slow erosion of confidence in government. This bill helps close those gaps. It gives South Africa a professional, impartial, and responsive public administration, as required by our Constitution. It strengthens efficiency through clearer roles, enhances accountability by empowering HODs, protecting neutrality during political transitions, and improves stability in coalition environments, something increasingly important in our evolving democracy. Colleagues, the choice before us is stark. Without reform, political interference will continue. Service delivery failures will remain unresolved, and institutional instability will persist. With reform, we commit to a state run on merit, not political loyalty. We build a professional public service that serves the country, not parties or personalities. And we lay a stronger foundation for rebuilding trust between our citizens and the government. This bill is not simply legislation. It is an opportunity for South Africa for a second chance, a chance to restore the professionalism of our public service, strengthen accountability, and deliver the quality of administration that our people deserve. Our committee therefore welcomes this Public Service Amendment Bill and calls on all members to support it. I thank you.
Thank you very much, Honorable de Villiers. I now recognize the Honorable Chief Whip.
Thank you very much, House Chair. I move that the bill as amended be passed. Thank you very much.
Honorable members, I will now recognize political parties wishing to make a declaration. The usual times for declaration of votes will apply. The DA.
Thank you. Honorable House Chair and honorable members, today we consider the Public Service Amendment Bill and the committee report. And in doing so, we confront a defining question for our democracy. Will we continue down the path of institutional decline, or will we begin rebuilding a public service that is competent, corruption-resistant, and genuinely committed to serving the people of South Africa? Imagine a public service staffed by qualified professionals appointed on merit, a workforce that reflects excellence rather than political favor. That is what this bill attempts to draw a clear line between governance and politics and to rebuild an ethical, capable state public service that puts citizens first. The Democratic Alliance supports the principle of professionalizing the public service, but we must place on record several concerns that remain unresolved. Chairperson, South Africans continue to suffer because government has failed to separate party politics from public administration. From cadre deployment exposed by the Zondo Commission to collapsing municipalities staffed through political patronage, the pattern is clear. When politicians handpick administration, service delivery dies. While this bill moves in the right direction, it does not go far enough. We still lack explicit enforceable safeguards to stop political office bearers from influencing senior appointments, shortlisting, or disciplinary processes. The DA has been consistent. You cannot professionalize the public service while cadre deployment remains alive. The bill proposes mechanisms to strengthen mobility, accountability, and performance management of HODs and DGs. These steps are welcome. However, without transparent and fair guidelines, the mobility framework risks creating further instability instead of strengthening capacity. We already know the consequences. Senior officials suspended on full pay for years while departments deteriorate. Chairperson, the DA has repeatedly requested clarity on critical issues. Who will manage the central register for disciplinary cases? What independent oversight will verify the information? And how will the manipulation of records for political convenience be prevented? Without clear answers, disciplinary processes remain vulnerable to inconsistency and selective enforcement. We welcome the incremental strengthening of the Public Service Commission's function, but let us be honest, the PSC cannot protect public servants from intimidation unless it is fully independent, properly funded, and insulated from political influence. South Africans deserve a watchdog with real authority, not one that must seek permission before acting. House Chair, our citizens are not interested in technical amendments. They care about outcomes. Will clinics have nurses who are present, supported, and resourced? Will police stations be staffed by trained personnel rather than political placeholders? Will teachers and principals receive the administrative support they need? A professional public service is not a luxury. It is a difference between dignity and suffering, between opportunity and hopelessness, between a capable state and a failing one. The DA supports any genuine effort to build a fit-for-purpose, apolitical, merit-based administration. We support the reforms that prioritize skills, experience, and integrity above loyalty. And we support measures that protect honest public servants from political abuse. But we remain unwavering. Until cadre deployment is abolished, political interference is criminalized, And until the PSC can act without fear or favor, South Africans will not achieve the capable state our constitution envisions. Chairperson, this bill marks progress, but not perfection. It is a step forward, not a destination. The Democratic Alliance will continue to champion reforms that build such a state, and we will continue to oppose any effort, legislative or otherwise, that keeps political hands on administrative levers. With these concerns noted, the Democratic Alliance supports the adoption of the Public Service Amendment Bill and the committee report. I thank you.
Thank you. The MK? Yes, honorable member.
Thank you. Thank you, Chair. Before the mighty MK comes in, I just
Yes.
want to rise on a point of clarity.
Mm.
Chairperson, the DA and the ANC are government. So MK should be speaking before the the DA, not the other way around. So can it be, can I ask that you fix it with the programming, that the MK must always speak first as the official opposition. Thank you very much.
Honorable members, it is unfortunate for you that I cannot solve the problem for you. But MK also sits in the Rules Committee. You also sit in the Chief Whips Forum. You also sit in programming. So when all these decisions are taken, the MK is there. And when the format of declaration was made, the MK was there. So it was supposed to be raised at that time, not now. And even if they are a government, but I think the proportionality here speaks that the second largest and so forth, and then we go accordingly. That is why the MK then is given 4 minutes. So we are not going to have this discussion. You'll take it up at the Rules Committee or at programming as the Chief Whip to the MK. MK? MK? Oh.
Honorable Speaker, the MK Party as the official opposition rises to state firmly that the Public Service Amendment Bill returned from the NCOP with amendments remain far from the reform South African desperately need. Let us not mislead the public. The amendments before us today are largely cosmetic. They are just definition, correct grammar, and replace must with shall. These technical improvements are welcome, but they do nothing to address the structural collapse of the public service. Clarity is not reform. Cleaning up wedding, head of department, political office, party secretary, and executive may assist legally precision. But South Africans did not vote for tighter drafting. They voted for a capable, depoliticized, and ethical public service. The bill does not deliver that. ICAIDA deployment, Honorable Speaker, is iphelelwe. Allow ministerial overreach, blast the line between the politics direction and administrative authority, fail to prevent political deployment, offer no protection for whistleblower, and lead DG and HOD exposed to political manipulations. These are the very fault lines that have produced decade of dysfunction. This bill does not close them. The ANC-led government has hollowed out the administration. The GNU ministers have dismally failed to make any impact. It's like they doesn't exist. The roads continue, unfunded vacancies masquerade as real posts, years of acting appointment, collapsing performance standard, a demoralized workforce, and a public service commission which is hand tied behind its back. A public service commission is in case. The bill does not fix performance accountability. It does not strengthen the PSC. It does not enforce merit-based appointment. It does not secure administration independence. It's lived the article of a wicked state completely in fact. As the official opposition, we place on record, we reject the idea that technically cleans up equal meaningful reform. We want that leaving political interference intact, keep corruption alive. We assert that South Africa needs a Public Service Act that shields administration from politics, not one that simply rewrites definition. We insist that real reform require empowered institution, enforceable ethics, and a clear farewell between the politics and the public service. Honorable Speaker, South Africa deserves a public service that is professionally capable and insulted from political abuse. The bill, even with NCOP amendment, does not move us close to that vision. It is a minimalized exercise that avoids the real problem, while the collapse of state capacity continues to rob our people of dignity. The MK Party will continue to fight for a true, independent, ethically, and high-performance public service. Sithi mhlale ngaphambili ake kuyobhekisiswa kahle kungadlalwa ngabantu base South Africa. I thank you.
Thank you. The EFF.
Thank you very much, as House Chair. The Economy Forum Fighters support the Public Service Amendment Bill. This reform is long overdue and presents a necessary step towards building a public service that is professional, ethical, efficient, and protected from political interference, especially at a municipal level. For decades, the public services has been paralyzed by the blurred lines between politically and administrative authority. Senior managers are too often appointed for loyal instead of competency, resulting in weak accountability and chronic failures in service delivery. This bill begins to correct these systemic problems. We particularly welcome 3 key reforms, but we were just going to be preferred if it's radically reforms. But nevertheless, first one, Chair, the devolution of administrative powers to heads of departments introduce a clear separation between policy direction and implementation. Executive authorities will set strategy and heads of department will be directly accountable for execution. This will end the habitual blame shifting that has undermined performance. Second, the limitation on holding political office through Clause 16, introducing Section 36A, is a divisive step towards ending cadre deployment by prohibiting heads of departments and their direct reports from occupying political roles. The bill reinforces professionalism and impartiality in the state. Thirdly, the transparent and lawful process for recovering overpayments strengthens fiscal responsibility. Clause 18 provides a fair mechanism for the state to reclaim funds paid in error while protecting the rights of employees. Chair, we are hoping that this bill is also going to address the weaknesses of MPEC in municipalities, because we have a huge problem there of weaknesses, stroke accountability. Thank you very much.
Thank you very much. IFP. IFP.
Chair, am I audible?
Yes, you are, Honorable Langa.
May I request to keep my camera off for better connectivity?
It's okay.
The Inkatha Freedom Party welcomes the Public Service Amendment Bill as a constructive step towards strengthening governance. We note its provisions to devolve administrative powers, clarifying institutional roles, and enhancing accountability mechanisms. These are important steps in advancing efficiency and service delivery. At the very same time, we must highlight certain concerns. Stripping powers from ministers risks weakening executive authority without addressing systematic failures. Challenges and inefficiencies within governance must not be confined to political executives alone. To assume that all political leaders lack competence or professionalism as a diagnosis undermines the acumen and the professionalization of the competent government officials who continue to demonstrate integrity and capability in governance. Our position is very clear. Accountability must be comprehensive, extending across all levels of governance. The IFP reaffirms its support to professionalizing the public service, ensuring that both political and administrative leaders are held to the same standards of integrity and competence. Responsibility must also be taken for shortcomings inherited from previous administrations as this bill builds on their work. The IFP supports this bill and the report thereon, while emphasizing that its success depends on credible implementation, shared responsibility, and a culture of professionalism across the public service. I thank you, House Chair.
Thank you, PA.
Honorable House Chair, honorable members, we as the Patriotic Alliance rise in full support of the amendments made to the Public Service and Administration Bill. This bill represents a critical step forward in strengthening the capacity, integrity, and accountability of our public service. For far too long, South Africans have suffered the consequences of inefficiency and poor administrative systems that fail to deliver quality services at the pace and standard our communities deserve. The amendments introduced bring much needed clarity, stability, and professionalization to public service. They promote a system where appointments are based on merit, where performances is monitored effectively, and where accountability is not optional but required. These reforms will ensure that public servants serve the people of South Africa, not political interests, not personal networks, and not those who seek to capture the state, but the citizens who depend on essential services every single day. Chairperson, professionalizing the public service is not a luxury. It is a necessity. It is the bedrock of service delivery, and these amendments create the framework for a capable state that works, responds, and delivers. We therefore express our support for the amendments made, and we commit to ensuring that the spirit and intent of this bill are implemented fully and fairly for the benefit of all South Africans. Thank you.
Thank you. FF Plus.
No declaration, House Chair. We welcome this bill and we support the report. Thank you.
Thank you. Action SA.
Thank you, House Chair. Our nation has been harmed by a harmful triad that has been growing over the last 30 or so years. That is a triad of incompetence, political connectedness, and corruption. And that is a triad promoted by us, the politicians, a highly toxic combination. We support this bill as the first step towards destroying that triad. Today, public service at all levels has become a place where you keep your job if you can't perform it. Our public servants can't do their jobs because most are not capable from the beginning. And they are preoccupied with keeping their jobs because they can't do their jobs. And the few that can do their jobs can't keep their jobs. If you're competent and you're ethical, you are not employable under the current political system. And that's because of the values that emanate from us as political parties and as politicians. The big question, Chair, is whether we as politicians can be considered public servants, and if the same rules can apply to us, so that we can professionalize politics and have a decent understanding that when you form a government, you need a civil service that can support any government that is formed by any political party. But that civil service needs to be competent, needs to be separate. Recently, we saw a minister in the GNU lose their job for apparently doing their job. Thank you, Chair.
Thank you. ACTP?
Thank you.
ACTP?
Thank you, House Chair. House Chair, the ACDP supports this bill as an important step to ensuring a public administration that is professional, effective, impartial, as set out in Section 195 of the Constitution. What is important is it establishes a clear separation between the political role of ministers and the administrative functions of public servants to prevent political interference in day-to-day operations. Now, this was highlighted by the Zondo Commission, which identified that the primary mechanism of state capture was the strategic positioning of particular individuals in positions of power, which was then used to gain control of public procurement and over law enforcement agencies. Corrupt politicians and officials used appointments and disciplinary processes to remove those law-abiding public servants and replace them with those who were willing to be complicit in corruption. And this was done under former President Zuma's administration, and sadly has continued, as we see in evidence before the Matlanda Commission and the Parliamentary Ad Hoc Committee. Chairperson, broad executive powers of appointment and removal without effective checks and balances allowed patronage considerations to pervade public administration and personnel practices, blurring lines in the political administrative interface. This the bill seeks to remedy. The bill has now been further improved by the NCP to include words or membership of a party's executive after the word party to ensure broader application. This the ACDP supports. Lastly, the ACDP shares concerns about long delays in finalizing disciplinary action against offending public servants, many of whom are suspended almost indefinitely on full pay. This cannot be allowed to continue unabated, as it severely impacts service delivery. Disciplinary hearings must be finalized
Honorable
quickly
Swa,
and without
your time
unnecessary
has
delays.
expired.
I thank you.
Thank you. UTM?
Thank you, House Chair. The UDM has long raised concerns about the erosion of administrative authority through political interference. For years, General Olomisa wrote to successive presidents of South Africa warning that when politicians usurp the powers of accounting officers, corruption becomes inevitable. We are now living with the consequences of that failure to act. This amendment bill takes an important step towards restoring professionalism in the public service by strengthening the authority and the accountability of the heads of department. By re-establishing a clear separation between political oversight and administrative functions, the bill helps reverse some of the challenges, the damage caused by, in particular, cadre deployment, a practice that has crippled service delivery in South Africa and has also crippled the institutional capacity of many institutions in SA. The public service should be the backbone of our development in our country. It should be capable of delivering efficient, responsive, and integrated services that meet the needs of our people. Yet today, it is marked by widespread corruption, maladministration, and underperformance, and persistent political interference. This has fueled a crisis of public confidence and left millions of South Africans without basic services. However, Chairperson, we must express a concern. I beg your pardon. The dysfunction in the public sector is not due to lack of laws or institutional clarity. It is the result of officials who fail to uphold ethics, misuse state resources, and operate with impartiality, without the impartiality required of public service. Strengthening the role of accountability of heads of department is therefore essential. It provides the legal foundation for more capable, professional, and stable public service delivery. However, Chairperson, we must express a concern. The bill moves in the right direction, but it does not go far enough in enforcing the professionalization framework adopted by the Cabinet in 2022. Without strong enforcement mechanisms, appointment may still be influenced by political considerations rather than merit. We cannot afford that situation to continue. Despite these concerns,
Honourable
the
Member, your
UDM
time is
supports the
now
bill.
expired.
Okay, Kositat.
Thank you. Rise. Pausa.
Thank you, House Chair. As Build One South Africa, we support the Public Services Amendment Bill. And we do so because South Africa urgently needs a public service that works, one that works for people, one that doesn't work for political parties, one that isn't working for connected elites, but for the people of South Africa. And so while this bill may be technical in its wording, its purpose is actually very political because it's about building a state that is defined by integrity, that's defined by competence, that's defined by accountability instead of patronage, protection, and the political interference that we have seen. The bill tightens definitions such as head of department and political office, which closes long abused loopholes that have allowed senior public servants to wear two hats, pretending to be administrators during the day while serving political agendas after hours. And we have seen this in the Madlanga Commission and in previous commissions. A truly professional state cannot exist with a system where political loyalty is rewarded over merit and where the line between party and public administration is deliberately blurred. And this is something that we've actually come to accept as a norm of sorts in South Africa that really must be separated in order for us to restore functional democracy. We've also got to be clear, though, that passing this bill is certainly not enough. The real test will be whether government finally enforces discipline, removes unfit officials, protects whistleblowers, and professionalizes the public service, to be honest, and to have capable public servants that actually work with pride for South Africans, the South Africans in this country who actually pay the cost of a broken state every single day. We want a capable state, and we've got to build it, and we believe as Build One South Africa, this bill is a necessary step towards a depoliticized and ethical public service. Thank you.
Thank you, Honourable Member. ATM. Al-Jama.
Malibongwe, Honorable Speaker, honorable members, beloved fellow family South Africans. As Al-Jama, we consider the Public Service Amendment Bill, B13D-2023, and the accompanying report of the Portfolio Committee on Public Services and Administration. This bill represents an important step towards strengthening the integrity, efficiency, and professionalism of our public services. The amendments aim to clarify roles within the administration and ensure that appointments and performance management are based on merit, accountability, and service delivery priorities. These reforms are essential in addressing long-standing challenges such as instability in senior management, weak disciplinary processes, and inconsistent implementation across departments. The committee's report highlights the need for improved capacity, stronger oversight, and a public service that is responsive, ethical, and focused on the needs of citizens. A capable state depends on a capable public service, one that is insulated and firmly grounded in constitutional values. Honorable Speaker, Al-Jama supports this bill. It advances professionalism, enhances stability, and strengthens our collective effort to build an efficient public administration that truly serves our nation. I thank you. Malibongwe.
Thank you, Honourable Member. The NCC, the PAC, UAT, good, the ANC.
Thanks, Honorable House Chair. The African National Congress, in its 55th National Conference, had resolved that the establishment of a strong, ethical, and capable state is necessary to grow the economy. One of the government priorities shall be the annihilation of corrupt activities and to instill a culture of ethical conduct in the public sector. Chief among the priorities will be the enhancement of the Public Administration Amendment Bill, which helps prohibit employees from doing business with state organs. The phenomenon became prevalent on the Zondo Commission inquiry. This phenomenon became prevalent in the Zondo Commission of Inquiry. The ANC-led government of national unity insists that the bill will help to curb these corrupt transitions and lead to improved service delivery to the people. This bill marks a significant milestone in the ongoing efforts to enhance the professionalism, efficiency, and responsiveness of the public service and administration in South Africa. It also improves administrative authority, accountability, and efficiency in the public sector. The Minister of Public Service and Administration proposal on the Public Service Amendment Bill, which intends to strengthen the public service and address policy reforms, is highly welcomed. It proposes revisions on the Public Service Act that will empower heads of departments. The proposed changes include granting administrative powers to departments, strengthening the Director General's function in the presidency, clarifying the Public Service Commission's role, and addressing appointment and career issues for the departmental heads. These reforms are essential for increasing accountability, combating corruption, and providing effective public service. It aims to align key features of public administration across all levels of government. The bill aims to strengthen governmental capacity and competency by transferring and seconding employees. The PAMA bill goes to promote ethical standards for public servants, reconfigure the National School of Government, eliminate inequalities in service conditions, and improve cooperation among public administrative employees. The Portfolio Committee commitment to the law demonstrates its commitment to creating a professional and capable state that serves the interests of South Africans. These progressive reforms aligned with the African National Congress resolutions and the National Development Plan, which prioritize public service change and development. Lastly, the PAMA bill aims to ensure that people with the necessary skills and capacity are attracted to jobs in areas when they are much needed for effective service delivery. This will insulate departments from political interference in the appointment of public officials, curb nepotism, and ensure proper skills match. The passing of the bill will enable the department and agencies to enforce compliance and ensure disciplinary actions against perpetrators. The ANC reinstated in its 2024 manifesto that it will continue to strengthen state institutions with technical capacity and skills personnel, and will ensure greater coordination and planning of service provision with the active involvement of citizens. The bill is in line with the policy aspirations and commitments to strengthen state capacity and build a capable and ethical state. Therefore, the African National Congress supports the bill in its entirety. Thank you.
Thank you, Honourable Member. Are there any objections to the motion as moved by the Chief Whip that the bill as amended be passed? There's an objection from MK. Are there any further objections? No further objections. Agreed to. The bill will be sent to the President for assent. The Secretary will read the last order of the day.
Debate on the report of P20 Youth Parliament.
I now call on the first speaker, the Honourable Kumbaka, who will introduce the debate.
Thank you, House Chairperson. The House Chairperson, Honourable Ministers and Deputy Ministers present, Honourable Members, fellow South Africans. On the 13th of June 2025, Parliament hosted the first youth parliament of the 7th Democratic Dispensation. The theme was youth economic participation, employment and opportunities, developing a medium-term youth development agenda for South Africa's youth. Under this theme, the historic gathering brought together the real voices of South Africa's young people, political youth formations, student leaders, young people living with disabilities, civil society, and young entrepreneurs. Today, as we reflect on the outcomes of that engagement and situate it within the P20 process, we recommit to one principle. Young people must no longer be at the periphery of domestic and global politics. They must be at the center of it. Honorable members, we do iterate that our foreign policy must reinforce a youth-centered approach in its people-to-people-centered approach. South Africa's foreign policy is rooted in justice, non-alignment, and sovereignty, but it is also rooted in memory of a painful past which still affects our existence in many ways, especially as young people. Tata Madiba reminded us, and I quote, "Nothing is impossible until it is done." Today, we carry his words into the global arena. Through the P20 Youth Parliament, we created a platform for youth to influence global governance, not as guests, but as partners. Fellow South Africans, the P20 Youth Parliament has already proven its importance. It created space for youth to speak on peace and security, climate justice, debt reform, digital transformation, and inclusive development. This was not a side event, but it was a declaration that young people are the heartbeat of a new and fairer multilateral society. One young delegate reminded us, and I quote, that we are the generation that refuses to inherit a broken world. That is the posture South Africa must defend domestically and also globally, most especially globally. A young African who is unemployed or underemployed does not experience global solidarity, but they experience global exclusion, and exclusion breeds instability. For peace to be sustainable, young people must have jobs, they must have opportunities, they must have access to skills, and they must be included in the common economies that shape their lives. Through the NYDA, the Presidential Youth Employment Intervention, the NASA's expansion, the Youth Challenge Fund, and rural broadband rollout, our government has laid important foundations. But as young people reminded us in the Youth Parliament, we do not want to be passengers in South Africa's economy. We must be in the forefront and driving it. Fellow young South Africans, our work aligns with Agenda 2063, the Africa we want. This agenda tells us that Africa will be transformed by a generation that is skilled, digitally empowered, and entrepreneurial and united. Across the continent, conflict continues to steal the dreams of young people. But as the AU's flagship initiative, Silencing the Guns by 2030, reminds us, peace is not the absence of war, it is the presence of opportunity, and opportunity is very critical at this point. Young people were clear. Young South Africans emphasize clearly that we do not want to choose between a meal and a dream. It is our responsibility to ensure that they don't have to be in that situation as parliamentarians of this good house. Honorable members, the world order created after World War II no longer reflects global reality, does not reflect Africa, it certainly does not reflect its youth too. With a population of 1.5 billion, with the majority under 35 years, Africa cannot remain a spectator at global decision-making tables. South Africa continues to push for permanent African representation on the UN Security Council and the UN advisory mechanisms across the UN system. And we need a reformed multilateralism that recognizes demographic realities, and that includes young people. In our BRICS countries, our youth are already leading in innovation and entrepreneurship, the digital economy, and shaping South-to-South cooperation. As one young entrepreneur said at the Youth Parliament, globalization means nothing to us unless it globalizes opportunities. Honorable members, youth inclusion matters for peace and stability in our country and the entire globe. Peace in Africa and the peace in the world will be won on will last depending on how we treat our youth and all our young people. If they are excluded, marginalized, or ignored, instability will grow. But if they're empowered, educated, and included, Africa will rise and thrive to its greater heights. Young people made this clear. Do not build a future for us, but build it with us. Furthermore, honorable members, international cooperation remains essential. Youth want mobility. Strengthening Africa's academic and innovation partnerships with BRICS the G20, the AU, and SADC will expand horizons for millions of Africans, young Africans, and South Africans who are ready to lead. We must also confront the digital divide. Without universal access to data, broadband, and devices, the gap between the connected and the excluded continues becoming a serious concern. Digital inclusion should be a priority because it is the new literacy at the end of the day. And as I conclude, honorable members, as we take the mandate of the P20 Youth Parliament, we must recognize that youth development is an investment in national security, economic resilience, and social cohesion. Countries that fail to integrate their youth into the economy pay the price, and the biggest price. But countries that place young people at the core of development planning reap the dividends of stability, innovation, and prosperity. South African youth are not waiting for tomorrow. They are leading today in various ways. They are thinkers, they are activists, they are innovators, and also creators. The P20 Youth Parliament brought us one step closer to where young people deserve and need to be. But it also left us with a responsibility as parliamentarians to ensure that the commitments made translate into actions felt by every young person in our country and in our continent. And as Comrade O.R. Tambo once taught us, and I quote, "A nation that does not care for its youth has no future." So it's very important that we secure the future as honorable members today. As I close, honorable members, the young people of South Africa need a future that is free from poverty, free from violence, free from exclusion, and free from the limitations of the past. Our duty is not merely to support our young people, but our duty is to unleash them to where they deserve to be. Honorable members, everything we do in this parliament must answer one simple question: will the next generation thank us or condemn us? Let our everyday actions in this parliament ensure that they thank us for many decades to come. For when South Africa's youth rise, Africa rises. And when Africa rises, the world will feel the power of a generation that refuses to be written out of its own destiny. Diabulela.
The next speaker is the Honorable Mkhize.
Honorable Speaker, honorable members, and the young people of South Africa. As one of the youngest members in this house, I stand here today with a clear message. Young people have been failed by the ANC, ignored by the GNU, and finally are finding a political home in the Umkhonto weSizwe Party. This debate on the report of the P20 Youth Parliament forces us to confront a painful truth. Young people speak, but the government does not listen. Young people participate, but their participation means nothing. Young people speak, but the government really doesn't listen. Young people show up, but the ANC and its GNU coalition continue to shut them out of real power, real opportunities, and real decisions. Year after year, the P20 Youth Parliament gathers brilliant, brave young South Africans. They speak from experience. They offer solutions rooted in the realities of poverty, unemployment, and exclusion. And what does the ANC do? They take photos, they clap hands, they write reports, and file those reports away, forgotten, ignored, and never implemented. This is why young people have stopped trusting the ANC. And this is why they are turning to the MK, the only party that represents their struggles and their lived reality. Honorable Speaker, South Africa today has one of the highest youth unemployment rates in the world. 2 out of 3 young people wake up with no job and no hope. The ANC created this crisis. The GNU is just making it worse. I say this not as a theory, but as someone who belongs to the generation that is being crushed. I have seen friends with degrees driving Ubers. I have seen young mothers choosing between bread and electricity. I have seen young mothers choosing between bread and electricity, and I have seen young fathers being unable to provide because the economy has locked them out. I have seen graduates living at home, not out of choice, but because the job market is dead. This is
Order,
a
honorable members.
statistic. This is a generation losing faith in its country. And while young people suffer, the ANC and the DA sit together in the GNU pretending to be saving South Africa, while in reality, they are saving each other. They say the GNU is unity, but let me tell you what it really is. It is a government of national convenience built on fear, desperation, and on protecting privilege. The ANC once promised young people economic freedom. Now, in the GNU, it has surrendered its economic agenda to the DA. The ANC once promised land expropriation. Now, the GNU has buried that promise permanently. The ANC once spoke boldly of empowering the youth. Now it speaks the language of its partners, the language of markets, rating agencies, and big business. It is not the youth who are guiding this government. It is not the poor. It is not the unemployed. It is not the forgotten communities. It is the elite, the connected. It is those who have never known hunger, never known the struggle, never known the fear of being young and jobless. Honorable Speaker, the MK Party will not allow the youth to be pushed to the margins. We will not allow young people to be treated as background dancers in a political drama. We will not allow the ANC or the GNU to bury the dreams of this generation. MK rises today as the true voice of South Africa's youth, because MK is made of young leaders, young activists, and young MPs who do not speak about youth struggles. We speak from within them. Our party was born of resistance, out of community organizing, and out of the real pain of real people. And that is why the youth trust us. They see themselves in us. They see their future in us. When MK speaks about unemployment, we speak as a generation that is living through it. When MK speaks about land, we speak as the generation that is denied of it. When MK speaks about education, we speak as the generation that faced NSFAS corruption, financial exclusions, and police on campuses that the ANC sent against students, while the MK stood with those students. The GNU tells young people to wait, but MK tells young people, let's fight for what is ours. Honorable Speaker, this House must understand that young people are no longer begging for a seat at the table. We are building a new table with the MK Party leading that movement. The P20 Youth Parliament must stop being a cosmetic event. We cannot be patting young people on the head and sending them home with empty promises. Youth participation must shape budgets, laws, and policies. The MK Party demands that young people drive national priorities, not not corporate interests, not all parties that are clinging to relevance. Honorable Speaker, let me close by saying this. Young people are not asking for miracles. They are asking for the basics: land, jobs, dignity, education, and opportunities. The ANC failed to give them these, but the MK Party is ready to fight for them with the youth, for the youth, and as the youth. As one of the youngest members in this House,
Honorable members.
as one of the youngest members in this House, I stand here today as a warning to the GNU and as a promise to the young people of South Africa. MK is here, MK is rising, and the youth is rising with us. Your voice will not be silenced. Your struggles will not be ignored. Your future will not be stolen. We will defend it with unwavering determination. Bokamoso ba lona ga bo kitla ba utswiwa, re tla bo sireletsa ka nonofo. Vumundzuku ba nwina a byi nge yiviwi hi munhu. Hi ta byi lwela ku fika emakumu. Julle toekoms sal nie gesteel word nie. Ons sal dit met onbewegelijke beshardenheid verdedig. Ikusasa lenu ngeke lithathwe sibhekile, sizozilela size siphumelele. Gwazamkhonto.
Yebo, ogogo.
Honorable members, order. Order, honorable members. The next speaker is the Honorable Gagau. Order, honorable members. May I ask the older members of parliament just to quiet down, please? Let's give the youth an opportunity to be heard. Thank you.
Ake lebohe motsamaiso dipuisano. House Chairperson, on the 13th of June this year, Parliament hosted young people across political and civil society formations under the theme Harnessing Parliamentary Diplomacy for the Realization of Global Solidarity, Equality, and Sustainability. Sadly, Youth Parliament has become an annual consolation day for young people who sit at the periphery of legislative and executive power in South African politics. A creation of some leaders in this house who refuse to recognize young people as capable and grown enough to contribute meaningfully to the running of this republic. Quite frankly, this periphery, disguised as a safe space for public participation and parliamentary diplomacy, exists strictly as an outlet for some of the eldership's fear of being outperformed and having their mediocrity exposed and replaced by a creative, competent, and youthful energy that this country so desperately needs. Honorable members, this needs to change. It cannot be that the average age of members of this House is 50 years old, with 45 to 64 years being the largest age bracket we have, while young people only constitute 8% of this House. We cannot be taking decisions about the future of young people with the fraction of young people we have in Parliament. We can and must do better. South Africa needs more young people to oversee its now and tomorrow. And House Chairperson, I can say this because I can stand here and say this boldly. As one of the youngest members of this House, a 28 years old second-term MP, given an opportunity to contribute meaningfully to the daily running of this country. An opportunity deliberately created by my political party, the Democratic Alliance led by Minister John Steenhuisen, because the DA gets it. And it is focused on ensuring that through the strategic positioning of young people,
honorable members,
conversation tables that matter, that this country is able to realize equality, good governance, and good quality living standards for all South Africans. Yes, I'm not alone, but there's not enough of us. Young parliamentarians emphasized what this country needs, which is good quality basic and tertiary education, an economy that works and affords young people a decent job with a decent earning to live a decent life. The ability to afford food, clothes, a home, a car, healthcare, their kids' school fees, a drink or two, and a funded December, all together without having to sacrifice one for the other. See, House Chairperson, without good quality education, the lives of today and tomorrow's generations of young people are easily destroyed. Raising children who are unable to read for meaning by the time they get to grade 4 means by the time they get to matric, they would have just winged it throughout the system to get to the finishing line. It means we are producing medical doctors with ChatGPT degrees, politicians and ministers who can't formulate their own sentences, let alone lead government departments, and an uneducated, poor, and unequal, but most importantly, dangerously hopeless society. And these horrors are the reason why the DA are in the GNU, to rescue South Africa and to restore hope. This is why we celebrate the Ministry of Basic Education's launch of a 496 million rands initiative to improve early childhood development. See, under the leadership of the DA's Minister, Siviwe Kwagobe, This initiative will restore the country's basic education standards in line with the Sustainable Development Goals of quality education, improved access to primary education in order to end poverty and inequality. Yes, House Chairperson, the DA gets things done. Halala wushe. However, it is unfortunate that I cannot sing the same praises for the SACP and ANC's Minister of Higher Education, Tate Buti Manamela. A minister at the helm of skills development in this country without the moral competence to steer higher education in the right direction. In fact, with him behind the steering wheel, this country's youth is more lost and without signal than we were before. A minister who breaks the rules to appoint failed CETA CEOs, all in the name of you scratch my back and I scratch yours, while leaving young people to fend for themselves in a system that has left their backs in the cold. A minister who thinks it makes sense to appoint a man clouded with the misappropriation of just under 2 million rands of South Africans' money for skills development funds as the person responsible for overseeing the country's sinking, corrupt, and ineffective CETAs. Oh, but it makes sense to him. It doesn't make sense to us, but to him it does. Because his primary goal is not transforming the PSET sector and ensuring that skills development in this country meets the goal of young people being more employable and expanding trade opportunities in sectors that will grow our economy. His focus is the enrichment of cadres who have soiled this country's public service and administration and destroyed the future of this country's youth. But all is not lost. Tshepo ya rona e teng mo ho Motlatsaletona la hae. Mme Mimi Kondo ya sebedisana mmoho le borakgwebo ba fapaneng ke qolla Takealot ho bona kaofela. Ho kwala kgeo se bakwang ke Ntate Manamela ka ho netefatsa hore ntshetsopele ya ditshebeletso tsa bokgoni e dula ka sehlohong sa lefapha. This all while shutting down bogus colleges that seek to rob and destroy the lives of young people. Ya motsamaiso wa dipuisano. Mokga Democratic Alliance o etsa dintho di etsahale. The DA gets things done. And it doesn't end there. The DA's Minister of Communications, Ntate Solimalatsi, has scrapped luxury tax on all smart devices under the cost of 2,500 rands, boosting access to technology for young people from rural communities, all while launching cyber labs for coding and robotics to match the country's needs for tech. I could go on, but these are just 3 examples of how the ministers and deputy ministers sent by the DA to go fight to rescue South Africa are doing that and just more. See, the bottom line here is,
Remember, your time has expired. Thank you.
There's an uncle in the furniture business, Joshua Doe.
Next speaker is the Honorable Dlamini.
Commander-in-Chief of the EFF, Commissars, Honorable Speaker, honorable members of the House, fellow fighters, and above all, the youth of South Africa. Today, we must speak with urgency of a nation in a brig. We stand here because millions of young people are being robbed, not by fate, not by accident, but by a deliberate, calculated structure that chooses inequality over justice. The youth are suffocating under unemployment, crushed under drugs, trapped by patriarchy, locked outside the economy, and buried alive in townships that were never meant for human flourishing. Yet the truth needs to be spoken in this House without apologies. When white South Africans suffered poverty in the earlier 20th century, the state mobilized with military precision to uplift them. The Carnage Commission of the 1927 created jobs, provided training, land, and guaranteed employment. Eskom, Transnet, ISCO, all were established to build white wealth. And it worked. White economic stability is not genius. It is not a miracle. It is a product of aggressive state intervention. But when the Black majority demands the same,
Suddenly the state becomes inefficient. Suddenly the private sector becomes the messiah. Suddenly the privatization becomes the gospel. This hypocrisy in its purest form, this is betrayal dressed as policy. The P20 report confirms that every township child already knows the poorer your community, the less life is valued. Township youth face the harshest unemployment, the deepest digital exclusion, the weakest education, the worst violence, the most drugs, and complete exclusion from policymaking. How can a young person in Mamelodi compete with one in Santon? One steps over broken bodies, the other steps in robotic labs. This is not inequality, it is engineered injustice. Those who benefited from state-created privilege now scream privatize because they know that privatization locks out Black youth forever. Privatization is not reform, it is a political crime. To privatize Eskom, Transnet, PRASA, and Sanral is in handover of the last remaining engines of opportunity to private profiteers. It is a declare that the youth of Guguletu and Kwamashu must remain unemployed, untrained, and unheard. Even in parliament, youth voices are filtered, censored, and sanitized. Youth delegations do not represent the unemployed graduates in Kwakuka, the young mother in Khayelitsha, the hustler in Kamashu, or the NSFAS burdened student. How dare we pretend to speak for the youth while excluding them from every table? How dare this house debate youth issues while shutting out the youth? Rewriting the economic rules in favor of the youth, not as a charity, not as a symbol, but as a binding law. That is why the EFF commits to a revolution of policy, not speeches. We will pass laws that force every sector of this economy to lift young people. We will not beg anyone to include the youth, we will compel them. When the EFF takes over this country, 40% of all public jobs will go to the youth by law, 40% of government budgets will be youth budgets by law, 50% of procurement will go to youth-owned business by law, SOEs will purchase 40% of goods, firms from the majority youth-owned by law. A monthly job-seeking allowance will sustain unemployed youth fighting for dignity by law. A youth loan guarantee scheme will end financial gatekeeping by law. The NYDA will be depoliticized and funded to uplift young women by law. And every private company will be compelled to employ 35% of the youth. We must confront another truth. Drugs are not the cause of youth hopelessness, they are the symptom. When a young person wakes up every day with no job, no skills program, no factory, no sports facilities, no hope, drugs becomes the only escape. A revolutionary state intervenes before the youth breaks. A captured state watches from a distance while the youth collapse. Education must be free. Education must be decolonized. NSFAS chaos must come to an end. Historic debt must be wiped out. Graduates must be supported into employment. SOEs must become the training grounds of the next generation. Education is not a cost, it is an engine of national survival. Honorable members, Cabal told us that if we act, we answer to our ancestors, our children, and the unborn. Today, the responsibility demands that we reject privatization, rebuild the developmental state, re-industrialize for the youth employment, and place young people at the front of economical battlefield. The youth are not the future, they are the revolution waiting to be unleashed. And the struggle for economic freedom fighters continues. The youth demand it, the youth deserve it. Mandla!
The next speaker, order, honorable members. The next speaker is the Honorable Zondo.
All right, House Chairperson. IFP, as IFP, we want to affirm the voice of South African youth, voice that spoke urgency, clarity, and conviction during the 2025 P20 Youth Parliament. What the youth told us is unmistakable. South Africa cannot speak of progress while an entire generation remain locked out of opportunities, marginalized by structures barriers, and excluded from meaningful decision-making. The IFP has long maintained that resolve the youth unemployment and social exclusion is not only an economic imperative, but a matter of national stability and security. The Youth Parliament session exposed the depth of these challenges. Young people highlighted the persistent disconnection between the education and employment, the failure of sectors to deliver the placement, and the devastating impact of limited digital and vocational infrastructure, particularly in rural and township communities. They reminded us that the priority of democracy rings hollow when learners with disability and marginalized young people, women remain excluded from opportunity and protection. Honourable Speaker, the recommendation arise from the Youth Parliament aligns strong with the IFP vision for a skill-driven, opportunity-rich South Africa. We therefore fully support the proposal to revitalize TVET colleges, enforce graduate placement target, and establish national youth entrepreneurship program focused on strategic infrastructure sectors. We endorse the calls to simplify business regulations, expand youth targeted funding, and create youth enterprise zones that offer tax-intensive and streamline the compliance intervention. The IFP has advocated for this for many years. The Youth Parliament also underscored the agent of rural transformation. The IFP support young people's demands for a fair access to land, strengthening agricultural colleges and youth-led cooperatives that can anchor the food security and local economic development. These are not optional extras. They are essential for ending generational poverty. Honourable Speaker, lezi nto esikhuluma ngazo siyibonile ukuthi ziyenzela. Long way before, we had colleges, skill development colleges, where we're directed and talking direct to the job market. When someone coming from those colleges, we're going straight to the job market. But now we have TVET colleges that does not help young people, does not place them directly to the core of the market of this country. We need to redirect our focus and give our people what will help them to achieve their goals. Young people were equally clear about the social inclusion. They called for a quarterly report on gender-based violence, gender-based and femicide intervention, enforce of anti-disciplinary laws, disability inclusive infrastructure, and expanded mental health support. The IFP shares these priorities. We cannot claim to champion youth while we ignore violence, discrimination, and trauma that may endure. Finally, we strongly support the establishment of youth caucus as announced by the Speaker of this Assembly during the Youth Parliament. We strongly support the institutionalization of Youth Parliament as an annual and accountable structure whose resolutions are formally tackled by the committees, including the Youth Caucus for monitoring and oversight. We further endorse the proposed Youth Compact and Youth Inclusion Scorecard as a tool to hold executive accountable. What South Africa lacks is not a vision. The courage and commitment to turn this plan into real opportunity for young people. The IFP stand ready to ensure that the commitment made to our youth translate into tangible changes. I'm not talking to you. In light of the issue raised, the IFP support
The next speaker is the Honourable Peterson.
Thank you, Honorable House Chairperson, members of the House, members of the public. House Chair, the first Youth Parliament of the 7th dispensation has made one thing clear. Young people are simply not asking for change, we are demanding it. The Patriotic Alliance believes that true economic liberation starts with bold reindustrialization. For decades, our communities, especially townships and rural areas, have been locked out of the economy. We propose focusing on light manufacturing, agri-processing, and digital industries so that skills and jobs are created where young people actually live. Chairperson, in this digital era, economic exclusion now comes in a new form. the cost of data, and lack of AI skills, young people cannot compete in a globalized world when data is unaffordable and digital literacy is a privilege of a few. We further believe South Africa must stop exporting raw materials only to buy them back at 10 times the price. Beneficiation driven locally will create high-skilled jobs and break generational poverty. To support youth entrepreneurs who are ignored by commercial banks, we call for a national youth trust funded through business tax, offering low-interest loans to real grassroots innovators. And yes, foreign investment must help South Africa grow, not extract. FDI must be conditional on technology transfer, job creation, and value-added production. We support the creation of a People's Empowerment Partner, a sovereign yield-style fund that gives equity returns directly to disadvantaged South Africans. We will not build a future where young people remain economic spectators. Chairperson, prioritizing citizens in employment is not xenophobia, it is economic justice. Enforcing existing immigration laws will protect jobs and restore fairness. Youth deserve meaningful engagement, not tokenism. Youth advisory councils, national service programs, and digital education platforms are the way forward. And as the youngest member of this House, it must be put on record. We cannot be passive, we must lead. Thank you.
The FF Plus. The Honorable Kobe. Order, honorable members.
Thank you very much, House Chair. House Chair, there is a common saying that young people are the future. Yet, while we make up the largest segment of the world's population, we remain the least represented in corridors of money. That the reality of the global structure is neither equal nor is it sustainable when 37% of the countries globally have no MPs under the age of 30. We cannot claim to represent young people when young people have no voice. This is why forums like the P20 are important, but they are not enough. In South Africa, people my age are confronted with multiple crises: a crisis of unemployment, a crisis of crime, a crisis of housing, and a crisis of education. These compounding crises can feel insurmountable, unchallengeable, and unchangeable. And yet, within each of these crises, we see the resilience, ingenuity, and bravery of young people every day. Their hope is an inspiration. It reminds us all of why we're in this parliament today. When we gathered at the P20, young people from across the globe raised a collective clarion call. We matter. Our voices matter, the crisis we are confronted with matter, and we will no longer sit on our hands and remain silent. Let us look at our very own parliament. Only 8.5% of members are between the ages of 18 and 35, and yet 32.6% of our country falls within that age group. This is not merely statistics, but a democratic emergency. How can we claim to be the people's parliament if we do not represent the young people of this country? We need young people in our political spaces, in our leadership structures, and at the forefront of solving the crisis that is facing our nation. As Action SA, we commit that through our legislative oversight and accountability, we will advance the development of young people as builders of communities and agents of change. We will advocate for the institutionalization of youth participation and integration of youth perspectives in all policy processes through youth mainstreaming to ensure that we as young people are determining our own agenda. It is in this spirit, House Chair, that we call for the establishment of the multi-party youth caucus in the 7th administration, not the next. This is the only way that we can ensure that the P20 Youth Parliament that we held earlier in July this year does not just become a talk show, but a lived experience in these very corridors. To the young South Africans who are watching, this is your house. You choose who represents you. You choose the voices that speak on your behalf. Throwing your hands in the air and tuning out will not solve the crisis that we face as a country. We need to collectively and bravely take action to face them, to fix them, and to fix our country. So this is my call to you. In your schools and universities, make your voices heard. In your communities and streets, make a difference. And when the next elections come around, do not check out. Take a stand. Thank you very much, House Chair.
Thank you, Honorable Member. The next speaker is the Honorable Thring.
Thank you, Honorable House Chairperson. The P20 Youth Parliament report reminds us that the future of South Africa rests on the shoulders of its young people.
Order, Honorable Members. Order.
In the report.
Order, Honorable Members. There's honorable members who are conversing so loud, especially there at the back, that I can hear what you're saying from here. Let's afford the other members the same respect that you want to be afforded. Thank you.
Chair, can I ask could I start again because
please, Honorable
I've lost
Thring,
my...
please
Yes, sir.
proceed.
From where, Honorable House Chairperson?
Please proceed, Honorable Member. You may decide to start again.
Honorable House Chairperson, the P20 Youth Parliament report reminds us that the future of South Africa rests on the shoulders of its young people. In the report, the ACDP emphasized that youth development must be anchored in values, education, and inclusive economic growth. Our ACDP youth argued in the face of a youth unemployment rate that remains above 40% that South Africa works when the youth work, highlighting the moral and social imperative to unlock potential through meaningful participation. The primary challenge youth face in South Africa is the mismatch between education and labor market needs, leaving many without the skills demanded by employers. Compounding this is limited job creation in a sluggish economy, restricting opportunities even for qualified youth. Before youth voices can be heard or heeded, they need employment. Graduates often finish school or university without practical skills. Technical expertise, digital literacy, and hands-on experience are missing, making candidates less competitive. Bridging this gap requires reforming curricula to focus on real-world applications and workforce readiness. Technology adoption is critical. Digital skills are increasingly required across professions, and affordable internet access without training can empower youth to thrive in a digital economy. Unemployed youth face social exclusion, mental health struggles, and vulnerability to crime. Communities with high joblessness experience poverty and unrest, undermining national stability. Entrepreneurship offers solutions. Young South Africans who start businesses generate income and jobs. Government small business departments can provide resources to support youth-led startups. The ACDP urges a return to vocational training, apprenticeships, mentorships, and career guidance. Public-private partnerships are especially effective in generating opportunities across sectors. As kingdom builders, the ACDP calls all parties to act decisively with respect to our youth so that they do not become a statistic, but the heartbeat of our present reality and indeed our future. Thank you, Chair.
Thank you, Honourable Member. The next speaker is the Honourable Kwankwa.
Chairperson, House Chair, because this is a P20 address, we must speak with a continental outlook. The challenges facing young people today are not only South Africa's challenges, they are Africa's challenges. And if we are to secure a better future for our youth, our solutions must benefit the youth across the entire continent. Africa is experiencing its most serious democratic backsliding in years. Since 2020, we have seen manipulated elections, a rise in coups, and attempts to remove constitutional term limits. These political disruptions, combined with growing inequality, have weakened governance. The Mo Ibrahim Index shows that overall governance has stalled, and in some areas, we are moving backwards. This decline is happening during our major demographic shift. Africa's youth population is expanding rather rapidly, and our working age population could reach over 1.5 billion by 2050. This could be a tremendous opportunity, but only if young people are included in shaping the decisions that affect them. Yet across the continent, young people are still excluded from formal decision-making. We have seen their power in movements such as Freeze Must Fall in South Africa, Sudan's March of Millions, Senegal's Free Senegal campaign, and Kenya's Reject the Finance Bill. These show the strength of youth mobilization, but that energy rarely becomes long-term influence in our institutions. At the same time, young Africans face serious socioeconomic pressures, high unemployment, poor access to quality education, limited skills development opportunities, rising costs of living, and barriers to start small businesses. Many also struggle with crime, substance abuse, and mental health challenges. These challenges limit the potential of a generation that should be driving Africa forward. House Chair, young people do not participate for show. Their contributions through the P20 Youth Parliament and other platforms must lead to real action. They must help us to shape policy, guide our legislative priorities, and influence executive decisions. Anything less is unacceptable. To reverse democratic decline, we must turn youth mobilization into lasting institutional participation. Regional bodies such as SADC, ECOWAS, East African Community, and African Union must protect democratic norms and prevent electoral manipulation and act when institutions or civic freedoms are threatened across the continent. They must also integrate youth voices into their structures and support cross-border youth networks focused on democracy, peace, and accountability. House Chair, the future of Africa will be determined by whether its young people are empowered not only to protest, but to participate meaningfully in building the continent they will one day inherit. I thank you.
Thank you, Honourable Member. The Honourable Schlazer Webster.
Two years ago, we were doing work in a community called Lipalale in Limpopo. And I met a young woman called Mahlodi. We were addressing a water issue and had gone to a river. The river was where everyone collected water. It was where everybody does their washing. It was where you can see nappies rolling down the riverbank. And so this young woman, Mahlodi, was there, and she was there to do washing. So I started a conversation with her. Asked her, Mahlodi, what do you do? Do you work? No, I don't work. This is a 21-year-old woman. Did you finish school? She said, no, couldn't finish school because there was no money at home. Even for me to have school shoes, to have a uniform, nobody works. There's no food. I couldn't get to school. But more than anything, looking at Mahlodi as she was doing her washing there, talking to her and just trying to engage her about a future, what struck me the most was that Mahlodi had no hope whatsoever. No matter how much I tried to engage her, to talk to her, Mahlodi had no hope. And what I saw that day is what I see when I meet a lot of young people in this country. The system that is broken has broken them. And they don't even have the will to fight or the will to hope or the will to dream anymore. And so we're here to talk about a report. And I couldn't help as I read that report to just see words. Because ultimately, the reality is that we can engage as we do in this house, but it's our responsibility to oversee the institutions that fail these young people. It's our responsibility to oversee an institution that allows young people to pass at 30%, because the reality is that it's a quintile 1, 2, 3 child that will suffer in the end because of that. It's our responsibility to oversee a system that will steal from a child, that will steal from a young person, that will steal textbooks, steal their future. It's our responsibility to oversee a system that will steal NSFAS, the opportunity of NSFAS, from a young person whose only opportunity it was to get into university through NSFAS, who steal from them through corruption when it comes to having opportunities to work and to have businesses. So really, I don't have much to say today, except we need to have a look at ourselves, the institutions we oversee, and we need to stop enabling institutions that break young people before even the system breaks them. Thank you.
The next speaker is the Honorable Low.
Thank you very much, House Chair. I am the oldest elderly young person to them, all of them. The P20 Youth Parliament could have said that young people are facing intersecting crises, including youth unemployment, educational inequalities, and digital exclusion. Yet within these challenges lies transformative opportunities that are led by the ANC-led government. These are guided only not by consciousness, but by a historic mission of liberation and equality that has prioritized youth empowerment as a central to South Africa's transformation agenda. The education remains the most potent instrument for breaking cycles of poverty. The ANC government has made unprecedented strides in expanding access to post-school education through the National Student Financial Aid Scheme. As for January 2024, the NSFAS received over 1.5 million applications and has provisionally funded 703 SASSA recipient applicants. The government allocated 4.2 billion in upfront payments for universities and TVET colleges to ensure that no qualifying student is denied registration due to financial constraints. Significantly and cardinally, NSFAS living allowance for TVET students has increased from 6,000 to 10,000 per annum in 2024, recognizing the real cost students face. Between 2019 and 2022, the National Student Financial Aid Scheme disbursed 123 billion to 2.9 million beneficiaries. In 2024, the government added the 3.8 billion specifically to support missing middle students, those whose families earn between 350,000 to 600,000 annually as per the threshold. This demonstrates our commitment to ensuring no academically deserving student is excluded from higher education due to financial circumstances. The ANC policy framework put emphasis in investment in technical and vocational education and training colleges, not as alternatives, but as a viable pathway to employment and skills development. Our TVET college budget has increased, honourable members, from 3 to 4% during the 2024 financial year. And the government called for the 10 sectoral memorandum of understanding with business to strengthen. Also, wish to recognize that the TVET colleges must be brought closer to employers to facilitate practical training and continuous upskilling of lecturers. Through the Minister of Higher Education, Honorable Buti Manamela, we have seen such programs taking place. The restoration and adequate funding of artisan skills training colleges remain a priority as they develop the technical capacity essential for industrialization. Honorable members, nutrition is foundational to learning capacity and child development. The National Nutrition Program provides nutritious meals to poor, vulnerable children every day. These meals comprise of protein sources, including soya, fish, eggs, milk, beans, and lentils, alongside fresh fruits, vegetables, and carbohydrates. And they are getting breakfast also. Recent achievements also include improved protein provision through canned peanuts and UHT milk, as well as deworming programs linked to feeding initiatives. Moreover, the government is committed to conducting an annual audit of youth access to social grants and safety nets, with digital mapping of coverage gaps to ensure no child is left behind. Mental health is quite critical, and mental health pilots using telepsychiatric and peer counseling models are being launched in 5 districts as I speak now. We also recognize the holistic the development that requires us to address psychological well-being alongside nutritional needs. It is quite important to highlight that early childhood development establishes the foundation for lifelong learning. The ANC government has attained remarkable progress in grade R enrollment, reaching 97%, comparable to upper middle income countries like Peru and Thailand. Access to ECD programs for children aged 3 to 4 has increased by approximately 15 percentage points. The Basic Education Laws Amendment Act now makes grade R compulsory, signaling the government's commitment to universal early learning. It also makes sure that provincial departments of education provide grade R in public schools and ECD programs, while infrastructure development and maintenance receive the high attention through the expanded work program and social sector grant. The ANC recognizes quality infrastructure and trained educators are inspirable. Both require sustained investment and provincial coordination to attain equitable outcomes. Honorable Chair, House members, the fourth industrial revolution demands a fundamental transformation on the curriculum. The ANC policy agenda calls for decolonizing the curriculum to integrate digital skills and make education relevant to the current and the future economic demands. This includes introducing coding, robotics, financial literacy into TVET and secondary school curricula, which investment in digital classrooms. The government recognizes that South Africa is poorly educated and underskilled youth who struggle to adapt to workplace demands. But we must shift the policy focus from purely academic achievement, but rather to practical on-the-job training as a key strategy to combat youth unemployment. The sector education and training and authorities are being reformed to improve workplace placement performance. Despite SETA's expenditure growing by 6.74% annually in between 2013-14 to 23-24 financial year, this funding has not translated into significant reductions in youth unemployment, but rather government has implemented a stronger accountability mechanism, including the enforcement of minimum 5% disability inclusion threshold monitored by parliamentary portfolio committees. When we zoom in access to data and connectivity, we need the digital exclusion in 2025 amounts to educational exclusion. Limited access to data, connectivity restricts young people from accessing university, TVET college, and SETA application platforms. As the ANC-led government, the digital economy and skills agenda, we propose nationwide training programs in coding, data analysis, cybersecurity, and digital marketing through public-private partnerships and community training hubs. The ANC-led government's comprehensive approach to social inclusion and access to education reflects our understanding that youth empowerment demands integrated, sustained interventions across multiple training. We are implementing policies aligned with liberation heritage and consultation commitments. Honourable members, the P20 Youth Parliament has provided clear recommendation, institutionalize youth participation, accelerate funding, disbursement, strengthen TVET colleges, modernize curricula, and ensure connectivity for all. The ANC hears these calls and commits to translate them into measurable outcomes. Our youth are not the leaders of today, they are the leaders of the current, and we must empower them accordingly. Together, we can make sure that economic freedom is today, is not delayed, is now. Amanga.
The next speaker is the Honorable Ismail Musa.
Malibongwe. Honorable Speaker, honorable members and fellow beloved South Africans, Al-Jamaa wishes to express our appreciation and acknowledge the efforts made in the success of the P20 Youth Parliament. The P20 Youth Parliament is a reminder of the powerful truth that young people are not only the future of our nation, but also essential partners in shaping its present. Their voices, their ideas, and aspirations are vital to a South Africa that is just, inclusive, and prosperous for all. As at this year's P20 Youth Parliament, our young delegates demonstrated a level of insight, courage, and social consciousness that inspires hope. They debated the pressing issues of our time, such as unemployment, inequality, justice, gender-based violence, and the strengthening of democratic participation. They did so not with division, but with unity of purpose and a shared determination to build a South Africa that works for everyone. For Al-Jamaa, the empowerment of youth is not a slogan, it is a moral obligation. Guided by values of justice, compassion, and social responsibility, we believe every young person deserves access to education, opportunity, and the dignity of meaningful work. we cannot allow the dreams of our youth to be stifled by poverty, marginalization, or lack of opportunity. Honorable members, the P20 Youth Parliament has sent us a clear message that young people are ready to lead. It is now our responsibility as elected representatives to listen to them, to act on their recommendations, and to open the doors of this very parliament to their participation and innovation. Al-Jamaa's submission is a call to justice, dignity, and collective empowerment. It demands a shift from tokenistic youth inclusion to meaningful transformation, led by young people with clear purpose and vision. Al-Jamaa urges Parliament to support youth-led, ethical, and faith-conscious development models that restore agency to the oppressed and provide real alternatives to systematic marginalization. Let us harness those young engineered energies to move forward. Let us commit to investing in youth leadership, supporting youth-led solutions, and building a society where every young South African can contribute to national development. The youth are our future leaders. As politicians, let us train and lead them by great example. I thank you. Malibongwe.
The next speaker is the Honorable Nodada.
Tlalo, a country that does not invest in its youth has no future. The investment begins with understanding that the youth are not just leaders of tomorrow, but leaders of today. And some of us sitting in this house are testament of that. Approximately 33% of South Africans are young people between the ages of 15 and 34 years. 40% of them between the ages of 25 and 34 years old are unemployed. 3.5 million of 15 to 24-year-olds are not in education, employment, or skills training. Skilled or graduates are still overlooked for cadres and the connected few for jobs. Many young people have become victims of gang violence and teenage pregnancy. Behind these statistics are the real faces of Tando in Bizana, in the Eastern Cape, who turns 36 next year and has never been employed and unlikely to get a job if things don't change for the better. Of Tsepo from Kroonstad in the Free State, who's a dropout because of poor foundational learning and now not in any employment or training. Of Xavier from Helenville in Nelson Mandela Bay, who has become a victim of drugs and gang violence. The face of Maria in Mamelodi, who is a victim of teenage pregnancy in one of the 30,000 child-headed households. And of Katlego in Johannesburg, who despite being a qualified graduate, had to fight against sleeping with the cadre to get a job. These statistics represent millions of young people who languish in poverty, unemployment, and crime because corruption has robbed them of basic service delivery and a future which will lift them out of poverty into opportunity. We must turn this bleak picture around so that their lives are not doomed before they even begin. That is precisely why the DA joined the government of national unity, to try tangibly change people's lives for the better. The P20 therefore resolved that at the heart of our solutions, we must end poverty, unemployment, and crime amongst young people through youth economic participation, employment, and opportunities. The P20 brought together a diverse group of young people from various sectors who shared their lived experiences and proposed concrete solutions to shape inclusive, youth-centered development policies, and it's our duty to implement them. Where every government department, parliament, and the whole of society should be obsessed about creating an environment where opportunity for young people is abundant. Nothing without us, they said. The following parliamentary resolutions to guide oversight, legislation, and budgetary processes, and to promote more inclusive responses and accountable youth development across all spheres of government were proposed to ensure that outcomes of the Youth Parliament are formally integrated in the work of Parliament and the government of national unity. Under education, the DA has long raised a number of key challenges also identified by the P20, including the persistent high rate of youth unemployment, in part due to lack of job opportunities due to poor economic growth and education outcomes that do not meet labor market needs and expectations exacerbated by SETA failures. Good quality education that focuses on early childhood development, that enhances literacy and numeracy must be prioritized, followed by developing skills that ensure we are responsive to economic opportunities, entrepreneurship, and the use of artificial intelligence so that young people are prepared for the changing world and are guaranteed an economically prosperous future. We have full trust in Minister Kwahube to achieve this. By investing in education, we can equip young people with skills, knowledge, and competencies needed to drive innovation and growth. Under economic growth, aligned with the P20 resolutions, the DA proposed overhauling restrictive regulations that deter hiring to instead foster an environment that promotes job creation, facilitates skills development, that encourages employers to hire and train apprentices and upskill them for the job market, slash red tape that holds back small businesses, and make it easier for informal traders to sell their goods and services by streamlining bylaws and regulations, expediting the licensing approval process, and assisting them to comply with health and safety standards. We as Parliament and the Government of National Unity need to ensure that all policies and laws are geared towards turbocharging the economy and creating jobs by attracting investment so that more and more young people get jobs or start their own businesses. By investing in industries that drive growth, we can reduce unemployment and stimulate economic progress. Parliament must ensure that the South African Police Service, in collaboration with relevant departments and entities, develop and implement targeted strategies to address crimes that disproportionately affect and exploit young people. These include, but are not limited to, statutory rape, gangsterism, drug trafficking, human trafficking, extortion, and the recruitment of youth into criminal networks. Efforts must focus on prevention, where community-based interventions are applied, improving policing and protection of vulnerable youth, particularly in high-risk and under-resourced community. And the DA's policy has been pushed in the GNU around crime to make sure that the GNU focuses on evidence-based policing, hotspot targeting, merit-based South African Police Service promotions, and trimming bloated management for more boots on the ground. We must clean out corruption and outlaw cadre deployment if we want to attract more investment to create jobs. We must hire people based on merit and qualifications rather than political connections, as well as ensure that money allocated to government departments is spent efficiently to deliver the basic services that will ensure more investment and jobs in local communities, which will benefit young people directly. WB Yeats summarized what we need to do to lift young people out of poverty, crime, and unemployment the best. But I, being poor, have only my dreams. I've spread my dreams under your feet. Tread softly, because you tread on my dreams. In our decision-making as lawmakers, let's make sure that these dreams don't end at the furthest mountain in a rural village, at street lights with graduation gowns, in coffins because of gang violence, or in cadres' beds because of a job. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Kutu.
Thank you very much, House Chair. I do not have a sad story to tell, so please forgive me, House Chair. I think, House Chair, before I start with my speech, maybe let's probably deal with some of the issues that the colleagues have raised, but also to locate properly the challenges that South Africa faces and the context to which we face these challenges. And I think the first point, Honorable House Chair, that I want to raise is how do we understand and locate South Africa and the South Africa's economy within the crisis of global capitalism, and how global capitalism inherently over time goes through a process of crises. And part of that process of crisis is the issue of the 2008 stagnation, that our economy has not been able to recover in relation to creating the needed jobs, but also how our economy has grown over time. And I think that if you really want to understand the South African challenges in relation to the economy, you've got to locate it within the template of global capitalism and understand that the problem inherently is capitalism and the system of capitalism. Now, another issue that you've got to contend with, Honorable Chair, is the issue of the rise of neoliberalism around the 1970s and 80s, which has pushed state intervention, which has pushed state intervention to the periphery of intervening in society. And of course, this neoliberalism, in a sense, has preached issues of structural adjustments, has preached issues of not spending, cutting spending of the state in social spending, in education. And of course, this has had a multiplier effect in relation to the livelihoods of our people. And the ANC-led government has been contending with these global dynamics. And the other aspect, Chair, is the penetration of colonialism in South Africa. That for the past 100 years, South Africa and the South African society has been clashed by the throat by colonialism, which has affected all aspects of our life and has taken over the structures of the economy. And that colonialism in South Africa, we call it colonialism of a special type, which has fundamentally expressed itself through race, which in a sense, the ones that own the productive capacity, the productive assets of our country in terms of ownership, control, and management have been, in a sense, white. And the ANC-led government, post-1994, has been at the center of reversing the legacy of colonialism. And so, in a sense, you must understand the 1994 political breakthrough as in context with these global dynamics and these dynamics, so that you understand the challenges that we're facing. And so the context of our democracy, in a sense, and we correctly capture the 1994 political breakthrough as a political breakthrough.
Oh, Honorable member, if you want to be recognized, just don't comment.
I
what's your point?
apologize, House Chair.
Hmm.
I was saying the speaker has been drowned. We can't even hear the debate.
So please proceed, Honorable member.
So we understand 1994 as the governing party, as a political breakthrough. And that is why we've been able to transform institutions to reflect the demographics and the will of the people. And that has been at the center of our work in the past 30 years. Now, if you understand that the fact that in this house now, you are shouting to the top of your voice, EFF leader, is an intervention of the winds on the gains of our democracy to change the outlook and the corridors of power to represent the demographics of South Africa. It's an intervention by the ANC-led government and the struggle of the liberation forces. Now, I thought that, Chair, we should deal with these matters, and before I get into my speech. So, Honorable Chair.
Order, honorable members. The honorable member doesn't have a lot of time left for his speech. Give him an opportunity to be heard.
And so I'm reminded, Chair, of an African writer, Chinua Achebe, as I'm hearing the sad stories, when he reminds us, and I quote, "The story we choose to tell about ourselves shapes the destiny we inherit." And I think, Chair, through the P20 Youth Report, young people tried to write a new story, one of liberation from poverty and inequality. And Honorable Chair, we commend the South African government and President Cyril Ramaphosa for successfully hosting the G20 summit, the first ever on the African soil. This platform allowed engagement with the world's largest economies on trade, investment,
Order, honorable members.
and
Order.
sustainable development. It positions South Africa as an attractive destination for foreign investment, especially in renewable energy, green industries, and ocean-based sectors. The removal of South Africa from the grey list further strengthens investor confidence and signals our commitment to transparency and stability. As part of the recommendations of the P20 Youth Report, House Chair, the youth proposed a comprehensive strategy for developing ports and renewable energy infrastructure, beneficiating natural resources to ensure that we create the much needed jobs, to expand skills programs and innovation ecosystems, linking them with SOEs and the TVET sector. And projects such as the Bucha Bay deep water port for hydrogen exports and the expansion of Nguga port will be crucial in unlocking mineral wealth, boost logistics, and create jobs. These investments also profit and uplift coastal communities. Honorable members, we must harness and invest in science, technology, and innovation. There is a greater need to establish innovation centers, promoting entrepreneurship, and investing in STEM education to prepare the youth for the fourth industrial revolution. We need to develop targeted strategies in green energy, maritime, and manufacturing to drive inclusive growth, especially in rural areas. Sustainable development requires integrating economic, social, and environmental priorities and building capacity in fisheries, marine tourism, and aquaculture to support the livelihoods and protecting natural heritage. House Chair, we the youth are not only the future, but the present drivers of change. By investing in skills, entrepreneurship, and digital literacy, we build a resilient and inclusive economy. We think that supporting youth-led entrepreneurship in digital literacy and access to technological education ensures that our nation's growth is sustainable and reflective of the dynamic global landscape. In conclusion, Chair, the G20 summit affirmed the renaissance of Africa, the rebirth of Africa and South Africa's potential. And in the words of Utatu Enoch Sondonga, and I quote, "Ngosikelele Africa, maluphaka uphondo lwayo, iva imathandazo yethu, usisikelele." Close quote. Thank you very much.
Order, honorable members. Order, that concludes the debate. Order, honorable members. I request members to stand
Lions roll!
and wait for the presiding officer and the mace to leave the chamber. That concludes the business for the day and the House is adjourned.
Sosa Investment